back in session at the annual planning meeting. We reviewed everything that's been going on with our different departments. And now we're sort of on the second tier to discuss sentencing guidelines and changes. The 8th edition, all recapped in an hour and 10 minutes.
Absolutely.
The executive director.
And I was just noticing that I don't see Brian or Christy, so my IT support is missing. So I'll try to stall and maybe if someone can find them so that they can share documents. Hey, Ryan, could you bring up the documents? And I'll tell you what the documents are as we go through. So thank you, Judge, and good afternoon again to everyone. What we're going to spend the next hour doing is sort of revisiting the sentencing guidelines, the proposals that were first published as working drafts in January, for which we had 6 public hearings. And then since then, we've been continuing to work through these issues and try to refine things, sort of with a goal of coming up with draft guidelines, hopefully by the December meeting, so then we can have public hearings on those draft guidelines. So that's sort of the direction we're taking right now. Back in July 28th, the commission had a special meeting where we started to work through what we called a markup of the sentencing guidelines. So we took the current sentencing guidelines, the 7th edition, Amendment 6, and we just identified areas that would change relative to the proposals we had there. And in sort of a systematic way, we went through the various proposals and how they plugged in. And that, I think, was helpful for a number of people. But at the end of that meeting, commission members suggested a number of areas to provide a little bit more detail and provide more information. And so I'm going to sort of use that to guide our discussions this afternoon. And we might not come away with a lot of decisions, but you'll at least see how the documents that were sent to you sort of fit into the discussions we had at the last meeting, the meeting on the 28th of July. So two sort of preface or preparatory comments. The first is, while our focus is on the sentencing guidelines and rebuilding the sentencing guidelines, one of the other things we're trying to do is to think about the other mandates the commission has and trying to make sure that when we're developing the guidelines, we're also taking into account any ways of coordinating or reconciling sentencing guidelines with other responsibilities. So let me just point out 2 or 3 areas where that might come into play. First, the commission now has a sentence risk assessment, which identifies cases where additional information is recommended to the court. And these are cases where the individual is a high risk or low risk case. And what we encourage the court to consider is either having a pre-sentence investigation prepared or a 4th generation assessment, a risk needs responsivity assessment. And if you live in Dauphin County, maybe you have a combination of the two, an RNR, PSI. So we see that as a best practice because it provides courts with really useful information about what type of intervention might be helpful to that individual offender. And this information might also be helpful to prosecutors as they think about negotiating pleas, might be helpful to the other parties. So we think, we build a tool into the system, and we hope there are ways to that courts start to think about how that can be more a part of the process, so that they get the information in a timely way and can use it to make better decisions. So one of the things to think about with a risk needs assessment is what if this person is high risk and high needs because of drug dependency or mental health issues? That might, the person might be a good candidate for some community-based alternative, some kind of for probation or probation with restrictive conditions. But because of recent case law, it's really important that the court determine what those conditions are at the time of sentencing. And so, with enough lead time and enough information, the court could have better information about what type of conditions to impose to keep the person in the community. So one of the things to think about with the sentencing guidelines is, what if you do have a case where it recommends mental health treatment or drug and alcohol treatment, and there's specific conditions that are warranted? Is there anything that we should be thinking about when we're building the sentencing guidelines to help accommodate that? And I think we sort of do that right now, where we have that trade-off at level 3, where we say, well, if you're, drug dependent, you can use comprehensive or clinical treatment in lieu of incarceration. I guess the question is, are there other opportunities for that? Are there things regarding mental health that we should be thinking about? Or what about problem-solving courts? Because many jurisdictions have problem-solving courts, and we don't have anything in the guidelines about the use of a problem-solving court. And so just something to think about as we're trying to organize and coordinate things is, are there sort of missing opportunities within the guidelines in terms of encouraging the use of programs and practices at the county level? So problem-solving courts might be one of those. And I'm not sure how it would fit in, but I just sort of mentioned that because we identified like it's a great practice, but we don't recommend it in any case. And even if we build it in sort of as we do now at level 3 to say, oh, a problem-solving court could be used if it's a certified court or a certified program, or if a person qualifies in this way, that it could be used in lieu of incarceration if it's a community-based mental health program or drug and alcohol treatment program. So just one thing to think about. Regarding resentencing guidelines and recommitment ranges, one of the things other jurisdictions have done when they're trying to think about sentencing guidelines and enhancements to guidelines is whether there should be some type of enhancement, or we should include in the prior record score if someone is under supervision at the time of sentencing, at the time of committing the new offense. And the reason I raise that is when we're developing resentencing guidelines, one of the factors is, was this a new offense that was committed versus a technical violation? And we give sort of premium, we give more weight to a new offense being convicted or committed while under supervision. And when we're doing the parole guidelines and recommitment ranges, we do the same thing. We provide sort of greater weight, and we take more factors into account if someone is convicted of a new offense or charged with a new offense versus a technical violation. The question is there anything related to that we should do with the sentencing guidelines instead of the recommitment guidelines or the resentencing guidelines? If you're going to say there's a premium, there's a price to pay for committing an offense while under supervision, do we do that on the new conviction offense, or do we do it on the revocation of probation or parole? But what we shouldn't do is do it on both, right? So it's just an issue to be raised as we're talking about sentencing guidelines. Is there anything we should do about a person being under supervision at the time of the offense? And if we do it in the sentencing guidelines, then we should not do that in the parole, in the recommitment ranges or the resentencing guidelines. And if we do it over there, if we have some kind of punishment there, then we shouldn't do it in the sentencing guidelines. So I don't know if there's, preference one versus the other. We certainly have built them into that back end, those revocations, but we could just as easily build them to the front end. And the reason I raise it as just something to think about is that in our legislation for the sentencing guidelines, we're supposed to take into account things like pattern behavior or course of conduct and things like that. And you could see how committing a new offense while under supervision might fit into that definition. So I just raise that not for discussion right now, but just as something to consider as we're building these guidelines. And the final thing that I wanted to sort of connect dots on has to do with our parole guidelines. The guidelines that the commission has adopted and that we're looking to have take effect in January of next year are limited to state parole guidelines. But our sentencing guidelines have recommendations about when someone gets a state sentence. It's about place of confinement. So if we recommend someone get a sentence with a maximum of 2 years or greater, or an aggregate sentence of that, we're then basically identifying the case as one that would be then subjected to our parole guidelines. And so, sort of in a purposeful way, we should be thinking about what are we doing at sentencing in terms of making recommendations about place of confinement, and then are there any things we want to sort of connect between our sentencing guidelines and the parole guidelines? So here's one thing just to, again, throw out as an example. Place of confinement is based on the maximum sentence, and our guidelines are based on the minimum term. And so you could see a situation where we would have a minimum term of confinement, where if you at least doubled that under the min-max rule, it would remain a county place of confinement. But maybe the minimum term makes sense, but the maximum term, that this is a case that might be better subjected to state confinement rather than county confinement. So you can see where the maximum sentence might be longer to make it a state place of confinement, even if the minimum is smaller. Now, I'm saying that understanding that we just have new legislation about short sentence parole, which is talking about, trying to make sure that we're keeping in county jails these kind of things. So what about the other side of that equation, which is, should we do something within the guidelines in terms of these shorter minimum sentences where we effectively cap the maximum, that we hold the maximum to double the min? Because what short sentence parole legislation was intended to do was identify these cases that could otherwise be served in a county jail because of the minimum, and treat them sort of like that if they're sent to state prison because the maximum got them there. So think about someone who gets a 6-month to 2-year sentence and heads off to state prison. They're a short sentence parole case. And the idea is, let's streamline everything we do at DOC to get them out. Because if they were serving that sentence at a county, they'd generally be presumptively paroled at their min. And so is there anything we should do in the guidelines that says, if this is a short minimum sentence, we should encourage courts to just double, for the max so that the case stays in the county and we're not sending them to the state only to have them quickly released to the county. So
isn't that opening up a whole can of worms, but something the guidelines have never done?
well,
Just recommend maximum. So,
Right.
I mean, I don't know. A, do you have the authority? Do we have the authority to do it? I don't know. But then you're sort of micromanaging, man. Because where do you draw the line? Yes, 6 to 24 is not good because the guy goes to state, but what if I want a 6 to 23 sentence
Right.
to keep county supervision?
right.
I don't know.
And I'm just raising an issue first on the terms of what are the guidelines or what do we recommend? You're right. We've always recommended the minimum term, but when the guidelines were first established in the early 80s, it's because the maximum is usually double the min, and because people usually serve just their minimum term. So the minimum term of confinement sort of related to the time served, and so it seemed like a good thing. We know that when we got into the 90s, people were serving way more than their minimum term, right? And so there was a little bit of a disconnect there. And now we get to this point in time and we have rules about place of confinement based on the maximum sentence, but we have guidelines based on the minimum sentence. And so it's, again, we don't have to do anything, but the commission purposely selected the minimum term because it made sense at the time. And I think it still makes sense. But it's just, if we're thinking about better coordination in the system, is there anything we would do? And maybe it's not the doubling, maybe it's just saying, if it's a minimum term up to less than 12 months, that, the maximum should be less than 12 months instead of, less than 24 months. So I just raised that because there's, I guess, opportunities for coordination that we should think about. And the other thing that impacts that are aggregate sentences, where we were just talking about a case where you have, lead offense looks like a state sentence, the lesser offense looks like a county jail sentence. If you're going to run them consecutively, all of a sudden you're creating an aggregate state sentence. Is there any guidance there as we're thinking about concurrent consecutive sentences about the impact of aggregation, where you're sending a case over to the state when presumptively for any of the counts we're focused on a county jail sentence? So again, there's not any recommendations linked to this. It's just to raise issues about the commission having authority in all of these areas where in the past it was all about sentencing. And now I think there's an opportunity as we're thinking about the sentencing guidelines to think about any kind of connections and any kind of efficiencies or better practices or whatever else that happen in sentencing that then imposes or addresses downstream things. So
I know, I'm sorry. I was thinking, there are times, I'm assuming you also do this, where you play around with those numbers because you know the time served and you see the need of the defendant.
Mhm.
So if you have somebody who's a perfect candidate for state drug court, you've seen them on the inpatient, you've seen that. But because they've been sitting for 6 or 8 months or sometimes a little bit more before their cases are disposed of, you use those tools because you want to get them up to the state to get into that program. Ultimately, if they are successful, they're going to be doing less time and
Right.
but those are things that we as judges are able to play with but for that, sometimes you're stuck with, they're going to be that short-term release, but they're not going to get the treatment that they
Right.
need.
Right. And again, I'm just raising these issues to say, these are, while we're thinking about everything, let's put it on the table. That makes all the sense in the world to me, that you want some flexibility, that you don't want to be locked into things. But on the other hand, the legislature had to create short sentence parole because these short mins were going to state prison because our place of confinement rules are based on the max. And so just something to think about.
And that's been preached to everybody for years,
It has.
not to do that. I don't know, the data show knows that the 3 to 24 month sentences in smaller counties, have those gone down?
Well, it's a fairly new thing. So we're going to be doing an analysis of short sentence parole. We're a little behind the curve on that one, but that's one of the things we're looking at to try to figure out first, where does it happen and how's it working? But then I think more importantly, what are the outcomes with the change in the legislation? Are they, is there higher recidivism? Is there lower? Is there a difference between what happens if you got that county jail sentence with a 23-month max and you got, the state one with a 24? So, that's why we have Bread and Company, and they're going to try to figure out what's happening.
Will they be able to determine what percentage? Because I guess part of it is that person who already had 8 months in, but their guideline range is, 13 months. So you give them
Right.
13. So they're going to be one
Right.
component of that, and the other component of it is the person who has.
Yeah, because of the time served issue. We can try to look at that. That's a really good.
And that is a
really good
big
issue.
problem.
I think it is.
First it's out for 8 months, now they come to you,
Yeah.
and they've already got that, and then the state's always complaining about
Right.
that. You give 1 to 2, well, they've already served 9, 11 months,
Exactly.
they're barely there.
That's right. Yeah.
So,
But in some of these things though, if things have changed a bit, but in the old days, if you had a 23-month or 2 years less 1 day max, these would be time served sentences. The case would come before the court and you parole them immediately, because they would have served them instead of thinking about. So anyhow, I'm sorry. First, Stevens.
How long have we been saying that it's 24 months in the top end, you gotta go to the state?
Well, since the 30s, I think, but I mean, the break of the 24 months has been there for a long time, but up until, I think JRI 1.
2008.
Yeah, 2008 with JRI 1 is when you could keep the person in the county up to less than 5 years. The difference with JRI 1 was that they changed over the rules saying, no, you have to go to the state unless your county has capacity, so 110% of capacity. And then the big change was, and if you keep them in the county, the court has parolling authority. Because in the past, the board would have to come in to handle all those county cases, and now that was given to the court. So, there's a number of counties that have that capacity. So judges can sentence to, those longer sentences in a county jail. But the huge exception is DUI. Any DUI sentence can be served in a county jail, and we now have F2 DUIs. So you can have a really, really long sentence in a county jail. The judge is the parole authority.
It's time to see capture planes. We have to just move that from 24 to 36 or 48 or something.
That's why.
Show how bad it
So
really
the
goes.
state sentence that you allow to serve in the county.
If your county has capacity.
Right, can you still do a reentry eligibility to auto parole them before their minimum, or you
Yes.
still?
You have all the authority. Don't you?
I
Or-
think it caps at 2 years.
Oh, does it? Okay,
So
I'm
I
sorry.
think, I'll double check.
Yeah.
But I was just looking at it this morning. I think if, let's say you did like a 1 to 5, less than that, I don't think the re-entry eligible.
No.
I think it's like the 2 year, but I'll double check.
Okay,
It's a good point. Yeah. Okay, so anyhow, that's just some things to think about because you all have the authority to do what you want to with these guidelines. So I wanted to just have you think about some of those connections. So let's move to the documents that I sent to you and sort of put them in or match them up to the working draft and the markup that we went through before. So the first thing we talk about with the text of the guidelines is the offense gravity score. What are the assignments of the offense gravity score? And there's several documents that we provided that talked about OGS assignments. So the first of these documents Ryan has posted deals with what we call new, modified, or previously unlisted offenses. So we gave you a document that was 6 pages, where maybe 7 pages, okay, 7 pages, where what we tried to do was identify any offenses that we want to just bring to your attention where these were added because of recent legislation, or there were changes in statute, or that we added some information in terms of that might impact the offense gravity score. So we're going to go through just quickly sort of a listing of some of these. And again, they're on the screen and Ryan can page through as we go through. But what I wanted to point out was the first category under section 2505 deals with causing or aiding suicide. So the reason this is highlighted was this was one of those areas where there was an enhancement under the guidelines. And what we tried to do if you look at this, is anytime there is an offense that is a crime of violence, so under section 9714G of Title 42, or where there's an enhancement, you'll see it that we build into the guidelines. You'll see the designation here. So COV means crime of violence or murder 1 or murder 2. And then E means that some enhancement is built into the description of the offense for the OGS assignment, because that's one way we can enhance the guidelines. We looked at the base assignment and we increase it because that factor the court determines that sentencing is present. So we increase the OGS for that offense. So in this category, we've identified a number of offenses that involve causing or aiding suicide. And those are listed along with the offense gravity score assignment. So again, we're not going to go through all the details of this, but I just wanted to point out that these were areas where we added some changes and then we came up with revised OGS assignments. So something that you might want to look at if you have any questions about the assignments. The next category, as we page down, is for simple assault. And one of the things that was was done in the assault statutes was we tried to break out, and this was a recommendation of the working group, I think. We tried to break out attempts from completed offenses. Because a lot of places in statute, these are combined together. And the commission talked before about having some separation between the two for attempts versus completed offenses. So you'll see some of that kind of breakout in this area. In some of these cases, we might have missed that in previous assignments in the guidelines, and so we're adding it in. We just wanted to bring it to your attention. The next category down is aggravated assault. The same thing here. We've highlighted those cases where there is where it's a crime of violence. And we've also included in this category the assault of law enforcement officers. So just bringing that to your attention, the breakout of attempts versus completed offenses there. And you'll see generally it's a 1 point or 2 point difference in the OGS assignment. Continuing down, we also have we have assault by a prisoner, and here there's a the breakout, or actually I think some new offense or new language in the statute related to deadly weapon likely to cause bodily injury versus deadly weapon likely to cause serious bodily injury. So those are designated there, and crimes of violence are highlighted. The next chapter 30 provision is 3011, which is trafficking individuals. And this is an area where we have, these are crimes of violence. There's an enhancement that applies to this, but the enhancement is pretty complicated. And so instead of trying to go in and creating all kinds of subcategories in this, we have separate enhancements, and we'll get to that later in the discussion. But this is just a breakout of the various offenses. And I think there's a new provision here where the minor is being subjected to sexual servitude, course of conduct. So we have added that in. And I'll get back to some discussions, but let me just point this out while we're here. If you look at the trafficking individuals, when a minor is subjected to sexual servitude and there's a course of conduct, I believe this might be one of those cases where the statutory max is higher and it becomes either a maximum of life or
40 life.
40 life, something like that. And so I just point this out because you'll see other circumstances in the guidelines where certain factors proven at trial increase the statutory max and create effectively either a life sentence or what we call a super felony, right? A maximum for a felony one greater than 20 years. And in the guidelines, in the matrix, one of the things we have created is a separate level of the guidelines for those kind of offenses. And they start at OGS 27. So we have a pretty high recommendation, a recommendation for a 0 prior record score starting at 90 months as a minimum term. And we say that's sort of the lower threshold for that category, that level of the guidelines. Now, we're not saying that every super felony has to be in that category. But what we're saying is if something's in that category, it's because it's a super felony, right? So one of the things the commission can think about as far as sort of a policy, a general policy for the commission is, what's the default when you see a conviction offense that's a super felony? Is the default that it goes into that category? So everything that has a statutory max of greater than 20 years has an OGS of 27 or greater? Or is the default the omnibus score we have for that super felony, which we have down at 22, which starts at 60 months? So that's just something to think about in terms of a general policy. Like what happens when you have that kind of offense and it's a new offense created by the General Assembly? If that happens, the default would be the omnibus score, and that's a 22, so it's 60 months, 5 years. But as a general policy, when the commission's assigning OGSs and you're looking at this and you're coming up with this table of offenses, is that a good enough default, or do we say, no, as staff is working on this for you, we should put it up to, 90 months? So something to think about. You'll see that shows up in a couple of other cases. And where it's really, I think, of a concern or prominence is when the statutory max is life. So it's not just like a super felony of greater than 20 years. It's a maximum of life. And maybe that's the distinction, that the omnibus is used for anything over 20, but if it's a life max, we put them up in that category automatically. So something to think about, because we can build it into the guidelines, and we can certainly build it into the draft assignments that we provide for you. Let's move down then to the next chapter, which is chapter 31, sexual assault. And you'll see there's a new offense there, institutional sexual assault by caretakers. And we come up with some general assignments there. And what we've tried to do with some of these is look at what we thought were similar circumstances and assign the same OGS to those cases. So peace officer, caretaker, other kind of categories of like, when there's a special circumstance, we capture that together and we assign those all in OGS 10. The next section of sexual extortion, you'll see a number of enhancements, and we're required to provide an enhancement if the victim is less than 18 years of age, if the victim has an intellectual disability, or if the victim is, or if the offender is in a position of trust. So you'll see that that's why they all were assigned that 10. It's a special circumstance, so we give that in OGS 10 as an enhancement. And you'll see then we carry that through to other sections of sexual extortion where we use that 10 consistently throughout that whole section of statute. So that, I hope, explains those kind of assignments. Moving down to the next section, we get to chapter 32, which deals with abortion. The only reason that's listed is within the listing in the guidelines, although we had assignments for these, I think we had assignments for those, we didn't have it in the text of the guidelines, in the list of the guideline offenses. And we rarely get these offenses reported to us, but nonetheless, we thought we want to come up with a comprehensive list. So we put all of these in, and then we came up with the assignments that they would have. And I'm seeing these are omnibus assignments initially, and so it could be that for many of these, we did not have assignments previously. Right?
Yeah, I think just generally speaking, so sometimes they're off chapters and we just may not have put them in, as Mark mentioned. Part of it, I think Mark can speak to this a little bit more, would just be sort of the economy of space when publishing the offense listing and so forth. So we always would account for them in SGS Web. So people would have them available there. But as Mark noted, they might not be placed in the offense listing that would have been published in the bulletin or in the commission's guideline manual, and therefore they retain that omnibus or omnibus association.
Thanks, Ryan. So the next section is chapter 33, and this has to do with arson. And here again, this is complicated because arson, I think we have 5 different factors we're supposed to consider for the enhancement for arson and for aggravated arson. And it just, it doesn't work well to build everything into the OGS assignments, but we built in a couple of the factors. And I think the key factors that we built into this assignment of OGSs deals with causing serious bodily injury to a civilian and causing bodily injury to a firefighter or others sort of employed in that. And so in both of those cases, we treat those individuals as like similar circumstances, and we give those an OGS 19, so it's a bump up from the baseline. But you're going to see over in the enhancement list, we have other enhancements about the number of victims or individuals in the property, the amount of damage done, and other things like that we have to account for in the enhancements. Moving through past the arson, we get to burglary. We've always had, or more recently, we've had an enhancement for burglary when it's a home invasion burglary, so the top type of burglary. So we always have given that at least, one step up from where we have it. And under the new guidelines, because we have more OGSs, it would be a 2-step. So we go from 13 to 15. But there is now a new enhancement that was just enacted, and that is for both burglary and criminal conspiracy or criminal trespass. There's now an enhancement if a domestic animal is injured or killed. And so, again, because there's all these different categories of criminal trespass and burglary, instead of building them into each and every one, we have a separate enhancement that we'll have. Thank you to the General Assembly. So those you'll see in a few minutes under that
That
provision.
was the domestic animal.
Domestic
We
animal,
also had a Titans law for canines.
yes, yeah. I don't think we have to do an enhancement for that. I think this enhancement was just burglary and criminal trespass. So again, you'll see that in a minute. Moving on to chapter 51, we have, I think these are new offenses. These are evading arrest or detention on foot. And so we built those into the guidelines. They're new offenses, so you might not have seen those before.
That might be Titans law.
That one,
Say that again?
Disobeying arrest, is that? I'll tell
oh
you.
yeah, RDM.
There was a dog, it was Jim Rapey, who's a former police officer. I guess there was a canine in his district that died in an elevator shaft.
I think that's this one.
That was in Johnstown.
Yeah, I think this is harming a police animal while evading arrest or
Yeah.
detention. Yeah, they're serious bodily injury.
This dog's named Titan.
It's not just evading arrest.
No, it's,
There's
well, there is an evading arrest and then separately evading arrest while or harming a police animal while evading arrest. I think there's this, and I'm not sure if it depends on who, I'm not sure what because there is it's in the same chapter that has obstructing administration of justice, and it has resisting arrest, and it has hindering apprehension, but this is new. So,
I think the dog fell down an elevator shaft in a pavement building.
Yeah, they were trying to find they were chasing it.
oh, we have more. So the next chapter, chapter 55, there are new offenses for police animals intentionally torture or kill. That might be it. Well, we'll have to see. So those there's some new ones and there's some modifications to statutes there. So we did assignments on that as well. Moving on to chapter 61, so violations to Uniform Firearms Act. This is just adding to the information we have there, the enhancements required by the statute. So the enhancement under 6105 for previous conviction or for possession or control of a firearm within reach of the defendant. We had built those enhancements into the guidelines before. We've adjusted those under the new guidelines. So you'll see there at OGS 18 up from OGS 15 is the baseline for that. Let me see what else we have. And then moving to chapter 63, and this gets a little bit complicated. And again, this is sort of like a twofer. This is sexual abuse of children. So this is child pornography. So we have numerous provisions of the enhancement that we're required to consider. Some of these we could build into the subcategorization, and some of these are handled separately. So you'll see that when we get to the enhancements, but at least on this list, anytime you see an E, you'll see that's because we have built into the description one aspect of the enhancement. And one of the big changes here was in the previous statute or before the amendment, the separation was, or the special category for minors was less than 13 years of age or prepubescent. And so we had two categories, 13 to less than 18 years of age and less than 13. With the change in the statute, they created a third category effectively. They said less than 10 years of age or prepubescent. And then we created the 10 to less than 13, and then 13 to less than 18. So there's now 3 categories of minors. And so so that's one of the factors taken into account. There's also a difference between first offense and second or subsequent offense, and that often impacts the grading of the offense as well. It's a pretty complicated statute. And then there's 3 different aspects of sexual abuse. There's photography, there is dissemination of photos and things like that, and then there's possession. And so the photography is generally seen as the more serious of the 3, and then dissemination and possession are the sort of the lesser in terms of grading. So again, a lot of factors, moving parts here, but what we tried to do was we tried to look at what the base assignment was based on the grade of the offense. And then we tried to look at any factors that had to be taken into account. So for instance, if the base assignment was based on just a minor, then the first factor that would increase the OGS by 1 was that the person was 10 to 13 years of age. And then if the person was less than 10 years of age, that would be a second factor. So 1 more step up on the OGS. And then if it was a second or subsequent, it would be 1 more step up. So each factor is effectively worth a point in the OGS. So we try to establish what the baseline OGS is for the grade of the offense, and then we build 1 factor steps for each of those. And then you'll see separately, we have the other factors like the number of images or the depiction of the indecent contact depicted, which I believe we build into this subcategorization as well. So a lot of factors in play, but just to give you a sense of how we went through and did the revised OGS assignments.
Just a couple things maybe.
Yeah, sure.
Titans Law is the one that dealt with the enhancement for burglary or criminal trespass, if there was an army. And then Act 95, that doesn't have a name, was the evading arrest and the arming of an animal. So those were the offenses. And then we go way back to trafficking in minors. It's a 40-year.
40-year. Okay, great. And we're going to find other ones. And when we get to the enhancements, I think I can point out the other ones, but they're pretty substantial increases. Okay, so those are just not just, but those were the new, modified, or previously unlisted offenses that we just wanted to call to your attention. We used, I think, a pretty systematic approach for doing the OGS assignments, but we wanted to give you a document that highlighted the changes. So if you had any concerns or interest in looking at that, you could find what the changes were. The next document we're going to look at deals with DUI. This is complicated too, but let me just hit you with a couple of key takeaways, and then encourage you to just read this on your own. So if you think about the DUI assignments right now under statute, there's a combination of factors that are in play. There is the nature of the DUI. What was the BAC? Was it chemical use? Was it other things like that? So there's those kind of factors. There's whether it's a first or second or third or fourth or fifth. How many prior DUIs were there? There are issues like, did the person have a prior homicide by vehicle or a prior, other kind of priors? Was there a minor in the vehicle? So there's a ton of factors. And so there's this sort of calculus that's in place to try to figure out the grade of the offense and the mandatory minimum that applies to that offense. And it moves all over the map. But the boundaries generally are at the lower end. The lowest mandatory minimum is 6 months of probation. And the highest mandatory minimum is 1 year of confinement, a mandatory minimum 1 year of confinement. But The grade and the mandatory are not always in the same sort of area, like you might have a higher grade and a lower mandatory, just depending on the combination of things. So under the current guidelines, what the commission did was, and it was before this got more complicated, but the commission basically said, we're just gonna simplify this, and we're gonna have 4 assignments for DUI or 3 assignments for DUI. Ungraded misdemeanor will have an OGS assignment, misdemeanor 2, misdemeanor 1, felony 3. So they'll each have just an OGS assignment. And then the mandatory minimum supersedes the guidelines. That creates sort of the floor for sentencing. And then you just sort of track it, and that's how it works. And if the first DUI, the first prior DUI doesn't count in your prior record score, otherwise everything else does. But as we looked at the changes in the statute and some of the other provisions of the statute, that no longer made sense. And when we had public hearings, there was sort of pushback about using that kind of rationale. It was just, it wasn't a good fit anymore. So we tried to look at a different way of doing DUI. And so what we arrived at, and how you'll see this works out, is we used as the starting point the mandatory minimum. Said use the mandatory minimum, and let's come up with an OGS that links to the mandatory minimum. So Ryan, if you could go to the last page of this document. So here's what we did. We said, if the mandatory minimum was 6 months, we're going to give it an OGS assignment of 4. If it was less than 30 days of confinement, it would be an OGS 7. 30 to less than 90 days, it will be an OGS 8. 90 days to less than 1 year, an OGS 9. And 1 year will be an OGS 13. Understanding that if the mandatory is higher than guidelines, mandatory supersede the guidelines, right? But at least this gives us sort of a starting point for the OGS assignments. Then we said there's going to be these cases where you have a low mandatory minimum, but you have a high statutory max. You have like an F3 offense, but you have a low mandatory because of just how the calculus works. So we should use as an override on those initial assignments based on the mandatory, the grading of the offense to increase the OGS assignment to make it more like comparable to the seriousness of the offense. So we said, use those first categories for the mandatories. Hey, this took a lot of work. Use those first categories for the mandatory to do the initial assignment. And then if you have, one of these grades that is higher, that will supersede. So let's say your mandatory minimum would have given you an OGS 7 because it was a mandatory minimum of less than 30 days. But let's say it's an F3 offense. Then the OGS would move from a 7 up to a 9. Or if the OGS was an F2, the grade was an F2, it'd move up to an 11. So you took those two things into account. So if you understood any of that,
Why don't you just have to do the second one? I guess that's what I missed. Why do you have to do?
because what happens is you have the reverse. What we started with and what we have under the current guidelines is just the second one. But then what you would have is you'd have some of those categories where the mandatory minimum is much longer. And because if we assigned, let's say it was an M2, you'd cap out, pretty high. And one of the complaints during the public hearings is, yeah, you have that person, but he has, he has a high mandatory, and we want to give a long. So anyhow, this is what we think might work, but it's really your call on whether it does. Yeah, and we can automate this. We can automate it. So here's one additional mechanism that we build into this. There are times, because you have these repeat offenders where they hit a 1-year mandatory, and the subsequent conviction is also a 1-year mandatory, and the subsequent conviction to that is also a 1-year mandatory. So what what we said is for purposes of the OGS assignment, when there's a second or subsequent 1-year mandatory, we increase the OGS by 1. So you'll see that the OGS for DUI for the 1-year mandatory is 13. If you have a second 1-year mandatory, it's 14, and if you have a third, it's 15. So we increase the mandatory to account for that. And then that would certainly put you at a point where you're far above what the F2 would otherwise provide, which is an 11.
So this is the within 10-year.
And this is the 10-year look back period as well. So then there's another, this takes into account all the new mandatory provisions.
Yeah, well.
And then, and so that's why you have these higher mandatories, but also there's 2 other provisions of this that you'll also see in other stuff. Man, this is tough stuff. The first is that the commission is required to provide an enhancement when someone is a 5th-time offender. And so we build that into these guidelines. That's why we have that +1 when you hit a cap. But we also there's also a provision of the new statute that there is mandatory consecutive sentencing if you're a 3rd-time offender or greater. So that is also one of the things that we'd be building into the concurrent consecutive policy to say, the statutory exceptions to any kind of rule we come up with mandatory, with concurrent consecutive would apply to DUIs. It would apply to homicide by vehicle while DUI when there's multiple victims, and it could apply to other areas as well. So very complicated stuff. Again, it would have been nice if we could have just gone with the grade, but I don't think that was going to work because of this lending that comes into place. So we think by starting with a mandatory and using that as the starting point so that you get something that seems comparable, and then using the grade as sort of an override to give you more, taking into account the statutory max. We think this accommodates it, but we will not be the judge of this. You will be the judge of this. So you have the document. Ryan, do you have any thoughts? Ryan and Maria really helped. His whole unit helped us think through this.
I think that was sufficient.
Okay. All right.
Is there, I don't want to create any more work on DUI, but if it already exists somewhere, is there, does somebody have a description or a chart or something that shows where the grading and the mandatories seem to be in opposite of each other?
We have a matrix that shows by tier, so by the BAC level, then it crosses as you have first, second, third, and subsequent. And we have like each discrete offense of the mandatories would be the grade of it. Actually print that off. Well, and it would show you where they sort of diverge. Like the 3rd time highest BAC is a 1-year mandatory. Then you see any 4th time, regardless of the BAC, becomes a 1-year mandatory. So there's the distinction by General Assembly was the grade, which increased the statutory maximum, but there was no increase in penalty on the mandatory minimum for its 4th and subsequent offenses, if you look at it that way. But it also occurs, and I guess I can add this in, it occurs in other spaces as well, where you have a 90-day mandatory, where there's an increase in grade based on the repeat offending, but the mandatory still remains. So that's sort of the disconnect, where you see an increase in the grade, the statutory maximum, but no change in the mandatory minimum. So those are the things we were thinking about.
Does that coincide with sort of the general falling out of favor of mandatories, and so the alternative was we'll just extend the statutory max?
I think so. I think that's part of it, and I think the second sentencing thing is part of that too.
I'm just wondering if there was an easy, concise way to identify where there's issues where it might be worth us getting a copy to figure out whether there's.
Right.
something
Yeah,
that
this
needs to
is,
be done.
well, as you know, like every attempt at this, it just becomes more complicated. It's really, I mean, this was, and trying to merge it into the guidelines. So one of the other takeaways from the DUI policy is, and one of the reasons we wanted to make sure the mandatory was sort of part of the assignment was then to say, DUI takes into account both the current and the previous offenses. So let's exclude, for a DUI conviction offense, let's exclude DUIs from the prior record score, because it's too complicated to figure out should it apply or not, and which ones apply, and did this increase the max, or was it the BAC that increased the max? You know, it's just really complicated. So we wanted to make sure that we captured in the OGS assignment mandatory and the grade, so that then we could exclude that from the prior record score. So if you have any other offense, DUIs can be used in the prior record score. But when we get to a DUI conviction offense, we're saying we're taking care of all of this in the OGS assignment. Don't worry about the prior record score. Now, if you have a burglary as a prior, count that, but we don't count DUIs in the prior record score. So we think this accomplishes that, but it's tough.
And then you have burglary, kind of DUI. as part of the
Right,
program.
right. Oh, absolutely, sure. Yep.
And then,
Okay, so
so-
I'm gonna drop that so that I can get through some of those other slides, but it's, but have it. So let me just highlight some of these other things. The next, document that I wanted to point out was what we call the level ABC OGS adjustments. And this was all about the public comment received, particularly in Philadelphia, what we received it elsewhere, that we created this new level A that's non-probation. It's restorative sanctions, but generally not probation. But there weren't many offenses assigned to that level. And so we were trying to look for misdemeanor 3 offenses in the crimes code that we could put at an OGS 2, that it would be recommending things like fines, community service, costs, things like that, but not necessarily probation unless someone had a prior record score. And what really sort of stood out as the one opportunity was theft of less than $50. Because we said, in many counties, or in a lot of counties, that might be handled by an MPJ under a local rule. And so why not sort of think about that in terms of, if it's going to be in common pleas court, think about that at that level too. And that got us to thinking about just the assignments generally for theft, and just coming up with a more consistent sort of proportional increase, step up as you look at the various categories of theft. So I think, Ryan, on that one, if you just page down a couple, there you go, that's good, that's good. So if you just take one of these categories, like theft by unlawful taking, moving property, if you start at sort of the top, you see, those exceptional things like disaster and firearms and so forth. Those are an OGS 12, so that's sort of the highest assignment. And those would be comparable with the highest dollar value, so greater than $500,000 or equal to $500,000. So that's an OGS 12. And then you'll see the next step down is the 10 at $100,000 to $500,000. And then from there on, we sort of correct everything so that they're just in ranked order. So 9, 8, 7, 6, 5. 5 is from $50 to less than $200. And then we drop the next one, the 5, what was assigned as the 5, down to a 2. So that less than $50 is an OGS 2. And then as you probably know, under the theft statute, under that chapter, there's like 8 or 10 different types of thefts. And they all have sort of the same kind of groups of loss. And so we just apply that across the board to all of them. So that there'd be this opportunity, theft's a fairly common offense and in Philly as everywhere else. And so we figured that this would be an opportunity to provide some offenses that were level A, that were non-probation, non-confinement recommendations. And we'd add that to what exists there, which is also a pretty big category, which is the A31 and A32 provisions under the Drug Act for paraphernalia and small amounts of marijuana. So those would be at level A as well.
So what paraphernalia?
What's that?
Paraphernalia is in there.
Yeah, it would be at 2, so it would be an OGS 2.
Disorderly conduct, is that?
I think we had that higher than that. I think disorderly conduct is at a 5. So, and I think it's just because our starting point was a misdemeanor 3, and then we were looking at sort of sentencing patterns and what judges were doing. And usually the default was probation. And so that's why I ended up as a 5, which was 6 months of probation. So, there might be others that could be dropped down. One of the things that we've actually recommended, and if you look at this list, and Ryan, I'm just gonna find something near the end, I think, if you get to like page 7. We add. Or page 6 rather, I'm sorry, page 6. Yeah, right there. So there's a couple of cases where we did have assignments at an OGS 2 that we were thinking maybe instead they should be an OGS 5, that probation should be possible. And these were what we saw as like obstruction types of things. So for instance, contempt of the General Assembly. It doesn't happen a lot, but it seems to me that, having probation as an option rather than non-probation, non-confinement may make sense, or obstructing emergency services, or unlawful listening to deliberation of juries, things like that, where there's some kind of obstruction to administration of justice, things like that those should move from a 2 up to a 5. So, I mean, we can keep those at 2, but they just seem like qualitatively different and something that at least the starting point should probably be a probation recommendation rather than the possibility of guilt without further penalty. So those are the ABC adjustments that you can take a look at, but I hope that at least provides a little bit more opportunity for the use of that level in some jurisdictions.
Mark, the move from 18 to 12 on some of these revised. That's just because of that you shrunk.
Because
down
we
the-
shrunk, that's exactly it.
So
Yeah,
the guideline range is the same.
that's exactly it. Yeah, in most of those adjustments, it is exactly that we just reduced the number. Remember, we took out 6
Right.
categories. So you can think that, especially when you get up past kind of 10 or 12, there's a six-step reduction to start with. And then if there's any adjustment outside of that, that's where you see it. And we didn't do a lot of changes like that. I think it was mainly down at the lower level.
So I thought the firearm went from 18 to 12 actually was.
Yeah, I think that was it, that it was because of that adjustment. And it could be that we also subcategorized it. I think there was another factor in place there. Okay, we don't have much time, so I'm going to close with this last one, and then we'll pick up things tomorrow morning during the policy meeting. The last one is the enhancement chart. And so we've started to talk about some of these things. And so I'll try to close with a little bit deeper discussion of the enhancements. So what we try to do is create a table that provides information on both those enhancements that we build into the OGS stuff. So the stuff I was talking about that we put in the definition and give the OGS assignment versus those that we have to add points to. We have to add stuff because it's sort of complicated. So this is the full list. So as an example, the first one listed is murder of the 3rd degree when the victim is less than 13 years of age. So we built into the sentencing guidelines an adjustment to murder 3, and we have a higher recommendation, I think 1 point up, when the victim is less than 13 years of age. So we build it into the list of offenses. So you can just see it as a separate offense. And if the victim's less than 13, then that's the OGS assignment. So you don't have to do any math. All you have to do is find the offense listing, and you have it there. But there's other ones, like the ones we have listed here in that second column, where it just doesn't work to try to build that into the listing. We'd have, thousands and thousands of sentences because of all the different combinations that could occur. So we come up with this list where in SGS Web, we'll just, if a person checks the box, we'll just increase the OGS by 2. So you'll get the sentence recommendation that's reflected in this, but we won't have it in the breakout list. So for instance, with trafficking in individuals, in addition to whatever's in the OGS assignments in that list, there are other things that could increase the OGS. These are enhancements we're required to consider. So the first is if the person was engaged in, was required to be engaged in sexual servitude. So we're recommending that there be a 2-step increase in the OGS assignment. The next one is a provision of the statute that says if as part of human trafficking, the person is also, in the course of the offense, the person is also convicted of kidnapping, rape, or IDSI, that there would be an enhancement. Well, this is the one that I was pointing to, that if you look at the statute, when that occurs, the statutory max for trafficking is life. And it actually provides for a life sentence if you want, so min and max of life, but it certainly provides a maximum of life. So, we in the past said, oh, that'll be a 2-step increase. But it seems to me that that's qualitatively different when the statutory max increases by that. And so there's 2 things to consider. One is, instead of a point value, this might be that case where we decide to give an OGS assignment when that occurs. And that's where that issue of 27 makes sense, because that's at the base of level F, where it's for those super felonies, where it would be a minimum sentence range starting at 90 months. Or the lesser would be you take the omnibus for a super felony, and that would be a 22, where it would be a 60-month minimum. But either of those would be substantially higher than what we presently have for trafficking. The other option, or an additional option, is should we be recommending that the sentence for trafficking run consecutive to the sentence for kidnapping, rape, or IDSI? Because there are provisions of statute like homicide by vehicle out of DUI with multiple victims. So we're trying to develop a policy around concurrent consecutive sentencing. And one of the questions is, do we use that in a way to either encourage or discourage concurrent or consecutive sentences? So, it could be that we don't recommend consecutive, but we make sure that there's a carve out that we're not recommending concurrent. Or we could be more proactive in terms of saying, no, in this case, it should be consecutive. And that these would just be recommendations, advisory recommendations. But it seems to me that in this circumstance, with that statutory max as a result of both of those convictions for both of those crimes, we should be thinking about what the recommendation, what the total recommendation should be. So we wanted to put that out for you to consider. And then the final thing is the next 2 categories or the next category is the age of the victim. And we had this built in before, and it's sort of an awkward way to think about this, but we wanted to have we wanted it to be more serious or a bigger enhancement if the victim was less than 13 versus a victim 13 to less than 18. And so we just do it where the higher age category is 2-point enhancement and the lower age category is a 4-point enhancement. So that's how we deal with that. And what we've done for trafficking in individuals would also apply to involuntary servitude. Now, there are some provisions that may already be in the statute, and so these enhancements only apply if that isn't already included in the description in the OGS assignment. So again, we don't have to make any decisions on this, but we wanted to point this out, and maybe tomorrow we can see if they're, what direction you want to go. The final thing to think about these 2 categories is there are a lot of factors in play, a lot of enhancement factors that we have to consider. And there may be a point at which you say, well, let's cap out. Let's say that you can only get X number of things to keep it sort of proportional. So I'm not sure what that is, but it's one of those things to consider for some of these where we have a lot of factors about putting in place some kind of cap on the enhancement. And it might be, 5 points or something like that, but you could really build up something and it's not very proportional after a while. Now, I think the exception is when the General Assembly says, oh no, there's a life max on this, then, maybe that steps outside of proportional concerns. So, Ryan, if you could just buzz down a little bit, we have a couple of other places where we may want to think about the guidelines or caps, and the next one is under arson. And so this at 3301. As I mentioned, in the guidelines itself, we subcategorize based on whether it caused serious bodily injury to a civilian or bodily injury to a firefighter. So that's already building in an enhancement in guidelines. And then we have all these other factors that we're required to provide enhancements for, 3 or more people in a building. And, it differs in terms of whether it's a F1 or a less than an F1, because when you get to the lesser offenses, a step doesn't give you as much time. Whereas when you get up to the more serious offenses, a step might be, a year or two. So that's why we broke out felony ones from less than felony ones. But you can see the factors, the 3 people in a building, the greater than $1 million damage, and the use of an incendiary device. So, with those point values, again, after a while, you might get up to 8 or 10 points. And so the question is there a cap that we should think about there? And then I think the next one, and Ryan, this would be on the following page. We get to, first there's the burglary, and I have a typo there, domestic animal harmed or killed, not of killed. So sorry about the typing, but so, the question there, this is a new enhancement. We're recommending just a 1 point increase, but that you can think about that and see what you think is appropriate. And then if you move down further to the sexual abuse of children, this is one we talked about specifically during the July 28th meeting. And for sexual abuse of children, we're required to consider a lot of factors, some of which are built into the statute. So that age provision and the indecent contact that's already built into the subcategorization. But then we have these additional things, the nature and character of abuse that's depicted, whether the child knew the defendant, that's a new provision that was added, and then the number of images. And the commission came up with these categories. So here again, there's not an easy mapping of this to the current guidelines because everything is just different in terms of the matrix. But we're trying to just figure out what's the right enhancement for child pornography, for sexual abuse of children. And so we don't know if there should be a cap here, taking into account that there's already 2 or 3 points based on what we have in the subcategorization. Should there be a limit on how many points is added for these additional values, 5 points or 3 points or whatever. So something to think about. I will note that there's a separate task force through PCCD that's looking at this offense. And we've raised the issue of enhancements here. One of the concerns raised by that task force and using our data was the failure to use the enhancement, that notice is, or the enhancement is not being used. So the 2 judges and I were just having a conversation before we started here about, what if you have an enhancement and no one gives notice of it or no one's mentions it. So, we can do some things as we're building these guidelines and this new application to try to hardwire enhancements when we know the factors are present. Because this is just a determination by the court. It's not proof at trial. It's a whole different issue. And the commission has always said, if the factor is present, the court must consider it in building into the guidelines. Then the court can decide whether to give that sentence or depart from it. But if the factor is present, it should be built in. And we found with this sexual abuse of children, this was not used very often. And it's a meaningful enhancement in a lot of ways. And so we need to figure out ways to make sure people use it. Part of the task force approach to this is really trying to promote better public education with prosecutors and judges about these enhancements. So not just this one, but all enhancements. But this is where it really was pretty stark.
Just to add, I know we're running out of time. We receive a lot of calls on the application of this enhancement. Keep in mind, the guidelines apply to the conviction offense, so it comes to also charging practices where some counties remaining unnamed will charge 1,000 counts for each individual image, and therefore then they can't apply enhancement. So I think that's something else for us to think about if we feel about certainly this, how do you deal with that as an area for this?
Yeah, thanks, Ron. That's a good point. So two final things, and then we'll close for the day. At the bottom of this page is DUI, and so I mentioned this before, but where there's 4 or more prior convictions under A1, C, or D, we're required to have an enhancement, and that's where we're recommending that for those 1-year mandatories, there be a step up in the OGS, so each of those up to a 15 would be in place. That's what we're recommending is the enhancement, but you may have other suggestions or ideas about how you want to proceed. And then the final thing on the last page is more a question or just, trying to think in terms of consistency in practice. And this might not be one of those areas of consistency, but I thought I'd point out anything. Anyhow, at the bottom, you might recall that the domestic violence enhancement we have is a 2-parter. What the General Assembly required us to do was come up with an enhancement that dealt with issues when there was a minor that was sort of sight or sound, some kind of domestic violence. And what we decided to do for that enhancement was to recommend that the court order the cost of assessments and treatment against the defendant. So that's how we addressed what we were required to do as an enhancement. Well, what the commission also did under its own power was create an enhancement where we had a 1-step increase if there was assault, etc., against a family or household member. And I remember we spent a lot of time going through like which offenses would be covered and so forth. So we came up with what is basically Article B, but we removed several of the categories. So we went with Chapter 25, 27, 29, 30, 31, 49. So through 31 includes our Article B, against injury against a person. But we're missing a couple of the categories there. And I think we selectively kept those out. But I wanted to just point that out because Article B is what we're using when we're differentiating in the prior record score, sort of serious felony 1 and felony 2 offenses from the others, where we're saying there's, not felony 1, felony 2, felony 3s and misdemeanor 1s. We're saying we're going to treat misdemeanor 1s and felony 3s as if they were F1s or F2s, if they're Article B offenses, as they involve a harm to a person. But in this area, we exclude certain chapters. So it's something to think about in terms of consistency in practice. As we tomorrow talk about the prior record score, we were encouraged to sort of carve out or treat more seriously those priors, and especially if they're F3s or M1s, if they're harm to a person. But we don't use that entire article for this. We have some carve-outs. So one thing to think about is when we look at the prior record score policy, should we use these same chapters instead of the entire article? When we look at this, should we use the entire article instead of carving out some chapters? So it may be that we do 2 separate things, and I get that. But because we're sort of in the same space, we should see if there's a benefit of some consistency between those 2 policies.
Can you spell out what the carve-outs were, whatever they were?
Yeah,
If we could see that, that would probably be a good comparison.
yeah. So
Do you want that now or just
Okay. Good answer. We'll get to that tomorrow. But thank you. So that's the one issue. I think the other thing is in the issues that we're dealing with prior records where we include Megan's Law offenses and Booth offenses. And so again, thinking about this provision, whether we should be thinking about any of those kind of things. So that's for discussion tomorrow. With that, we're past our due time. We've covered a bunch of the materials that we provided to you. We'll pick up on some of this tomorrow morning during the policy meeting.
Good morning, everybody. We have a nice attendance present here, and I believe we also have participants via Zoom. So I'll be opening the policy meeting this morning. We're going to pick up where we left off from yesterday afternoon with Mark Bergstrom reviewing the proposals for the 8th edition of the sentencing guidelines. And we talked about a couple of things yesterday that we have some answers to. So I think we're going to get those clarified and then move forward. And we are going to be wrapped up hopefully by a little before 11 and then take a break before the official meeting. So Executive Director.
Thank you, Judge, and good morning, everyone. Yesterday afternoon was long and tedious and painful in terms of trying to go through and look at the assignments of OGSs. And let me just sort of back up a little bit and explain why we did that. And part of it is that we've spent a number of years now, and the commission has spent a number of years trying to come up with general concepts and policies to guide everything that we're doing. And then staff takes that as sort of directions in terms of trying to implement it. And one of the areas that is very tedious and difficult is when we have thousands of offenses trying to make sure that, you know, with fidelity, we are sort of applying the rules. And so what we try to do is do that, provide it in advance to members, and then during a public meeting, try to explain some of the highlights of those assignments. But it doesn't make it any less painful. But the reason we do that is to first make sure we're on the right track so that we can have a course correction if necessary. To make sure there aren't any surprises so that we point out everything and maybe we highlight some things that we're not sure about in terms of do we need a refinement of a policy. So yesterday, I want to point to 2 or 3 things that we discussed that sort of fall into that category. So the first was we talked about certain offenses where, like with human trafficking or other things like that, where based on either related behaviors or second and subsequent things like that, you might end up with a super felony, an offense that starts as something at or less than a felony 1 with a statutory max of 20 years and is increased to a felony 1 that has a max greater than that. And sometimes that greater max is, 40 years, but sometimes it's life. And it sometimes allows for a life sentence, a mandatory minimum and maximum of life. So staff was sort of unclear what type of general assignment we would have for that, especially when there's an enhancement. Because under sort of the rules we had in place and trying to apply what the current guidelines prescribe to these new guidelines or proposed guidelines, the recommendation would have fallen far short of what we generally have as an assignment for a super felony. So that was just one example of trying to get some guidance from the commission about how do you deal with that kind of situation where, maybe an OGS of 20 or 22 or 24 would sort of typically make sense in using the current guidelines. But under the new policy we've talked about, it might go up to the omnibus score for felony 1, super felonies, or up to that top category that we have that's sort of limited to those felonies with a max of greater than 20 years. So again, we just wanted to point that out. What we're trying to do is work towards staff being able to prepare a draft of the guidelines for your review in December. And so where we have these kind of questions about policy or implementation, we're just trying to bring them to your attention. And then, as I said, we also want to make sure there aren't any surprises. So if we just see things that don't look quite right, we wanted to bring it to your attention so that then in December, when we're discussing it, you've had some time to think about it. And a good example of that are the enhancements, where we said, we're trying to build in all of these requirements of the enhancement. In some cases, it's required by statute. But sometimes it starts to look disproportionate, that there's, 6 or 7 or 8 different factors that we're taking into account with the enhancement. And if you add a point or two for each, all of a sudden it becomes this really, large sentence recommendation that seems sort of outscale. And so that's where we're looking at it and saying, should there be some type of cap in terms of, the sort of the upper limit for how much the enhancement changes the base recommendation. So again, we're not looking for answers, but we're trying to highlight these so that when staff comes up with a draft for you to review in December, that we can sort of return to this and say, does this work for you, or is there something you prefer us to do? And certainly between now and then, if there's any issues that we've covered or that come to your attention that you want to pass on to us, we'll incorporate that into the draft, and then all the members will be able to review it in December. So that's just, I just wanted to sort of return to that and just sort of frame things, because yesterday was, at least for me, it was painful, and so I'm sure for you it was painful as well. Let me just mention one other thing, because we talked about specific assignments for DUI, and I just wanted to return to that to hopefully give maybe a better or clearer explanation of the process. Our guidelines address minimum terms of confinement. So all of our recommendations about confinement are about the minimum term. And if you look at the DUI statute and all the mandatories and all the complications of the DUI statute, including the most recent changes, there's a blending of mandatory minimums and classification of crimes, grades of offenses. And in the past, we were just using the grade of the offense to come up with the default assignment for the OGS. But if you think about it, that's about the maximum term. It's not about the minimum term. And everything else in the guidelines is about minimum terms. So that's why we're sort of flipping the approach. We're saying, let's use the mandatory minimum to designate that minimum, that OGS assignment. And then let's use the grade of the offense as sort of an override to increase the OGS assignment when you run out of real estate, or when, the General Assembly has indicated, oh, this is more, it's notwithstanding what the mandatory minimum is. So I don't think either way is going to be perfect, and there's always going to be sort of these overrides. But I think the approach of going with the mandatory as the sort of the primary driver in the assignment under this new complicated system, I think makes more sense, because it'll be more of an appropriate fit to start with. And then using the grade as the override allows it to be increased. So again, that's the logic. We can rebuild that if you think we should, but we'll continue on this track, build that into the proposal we give you in December. But again, if you have any suggestions, let us know. So with that, we're going to move from the discussion of OGS to other factors in the guidelines and the proposed sentencing guidelines. The first document I'm going to ask Ryan to share, and we're going to try to make sure when we're sharing the screen that we can continue to see who's online, because that was sort of difficult yesterday. So we're going to share the screen, but retain either the participant list or the photos of people on the side. So the document that I'd like to share is the big listing of all of the offenses. So the title is Sentencing Guidelines Proposals, Proposed OGS Prior Rec Score Assignments. And it was a mere 37 pages. So I'm sure you all reviewed this carefully, but so this is where we took all of the other changes we were proposing or suggestions we had about reassignments and so forth, and we plugged them into a single document. And we probably went overboard with this document. We tried to make sure, this is just the crimes code, but we wanted to make sure that we included just about every offense we could find in the crimes code. Now, in terms of eventually publishing this and having it as part of the guidelines, we're going to find that there's chapters in Title 18 where the offenses are rarely reported to the commission. There's very few conviction offenses for those. And the default that we have is the OGS assignment. And you're going to find a lot of those offenses listed here where we're basically recommending as the OGS assignment, the omnibus score. And so in a practical sense, when we finally publish guidelines, I'm not sure that you need pages and pages of offenses, that the default is just the omnibus score, that the commission hasn't done any special assignment. They've just sort of agreed to the omnibus because we know the omnibus is the fallback. If an offense isn't otherwise listed, you use the omnibus. So I just mentioned that we wanted to give you all the details that you knew what the assignments were. But I think staff will go through and identify chapters where everything is an OGS, is an omnibus assignment. And maybe instead of providing all the details of that, we'll just list the chapter and indicate the omnibus score applies. Because that might just be simpler for everyone to see and work with. And there's also titles of pardons where we get very few offenses and everything falls under the omnibus score, like game violations, things like that there's reported offenses, but they're all omnibus score. So probably no need in detailing all of that. So just as a general approach, that's what we're thinking of as we bring stuff to you in December. So in this big document, what's new and different from the last meeting was we added the revised working draft OGS assignments. And special categories and so forth, but we had in effect 36 that deal with typical offenses, and now we have 30. So to some degree, in some of these areas, there's just going to be a 6-point discount. But we also we did other alignment. We combined some things and we expanded some ranges and stuff like that. And so this new listing just takes into account what was sort of the best fit as compared to what we published in January. So that's the first thing that you'll see. The OGS assignments take into account that recalibration and then the changes we discussed yesterday. The second column, the one to the far right, is prior rec score values. And this gets to this whole new approach to prior record score. And we wanted to find a sort of streamlined and easy way to explain prior record score. And so I hope this does it, but let me sort of go through the explanation. Under the current prior record score policy, what the court's required to know, or whoever's preparing the guidelines is required to know, is for any conviction prior to the date of the offense, the approach is that you look at each of the judicial proceedings or each of the criminal incidents, I guess, in which a person was convicted of prior offenses. And the lead offense of the judicial proceeding is considered in the prior record score. You figure out the point value of that, and that's included in the prior record score. And then you take into account any consecutive sentence. And for each of those offenses, those are included in the prior record score. And then we have a list of offenses, and we say, and it's linked to the OGS, but we say these offenses are worth 4 points, and these 3, and these 2, and these 1. And then some of these are less than 1, and you have to sort of add them up, and then you cap at 7 and so forth. So it's pretty complicated in figuring out the prior record score. But that's the approach we have right now. And so as the commission's talked about simplifying and streamlining the prior record score process, the approach that we've discussed was, and what we published in January was, that you look at all prior convictions, any conviction prior to the date of the current offense. You identify the most serious offense, and then you determine how many other priors have that same level, that same grade or same level of seriousness. And so you end up with a very sort of much more simplistic approach. Just look at all prior convictions, identify the most serious, and then is there one of those or is there more than one of those? So, Judge?
So Mark, you're looking at if somebody has one incident and they've got 5 convictions, are you looking at all 5 of those?
We
now?
are.
Not
We are.
just the lead offense.
Right, not just lead offense. And one of the reasons to sort of take this approach, and we've talked about this before, is the processing of cases from county to county and almost municipality to municipality varies. So in some counties, there's sort of a consolidation of things and you just focus on the lead offense. And in some counties, every offense is charged and you get a conviction for everyone. And we've tried a number of different ways to try to accommodate all that. And there's just not an easy way to do that. And then we, one of the accommodations was let's build in this concurrent consecutive thing. And that didn't really help either. And so we've sort of gone back to saying, let's just look at what all the conviction offenses are. And then let's have a streamlined way of counting them. Because even if they're in the same incident, you might have multiple victims, you might have, there might be in a judicial proceeding, there might be multiple incidents, right? And so it's just, there's no easy way. And so if we're going to try to automate this and simplify it, let's just look at every conviction offense. Let's figure out what the most serious thing is, because that's an important factor. And then let's figure out how many of those there were. And so that's the, there's pluses and minuses, but that's how judges can aggravate, mitigate, or depart, right? But as a general policy, that would be the approach. So when we took that to public hearings, I think, there was some, I think, support for the simplification and automation of that. One of the concerns was the categories we came up with seemed to, there were concerns that some offenses were left out. They were treated less serious than they should have been. So what we're proposing here, and this takes into account what we heard in public hearings, is there's in effect 4 categories of offenses. So the first and most serious category is crimes of violence. So defined in 9714G. But if you look at that definition doesn't include murder 1 or murder 2. So we add that into the mix, right? So it's criminal homicide, or at least murders, and then any other crime of violence. And that includes inchoates to that. So that is the first category and the most serious category. The second category we originally said were felony 1s and felony 2s. But when we had the public hearings, and particularly from the AG's office and many of the DAs, there was a concern that there are some really serious felony 3s and even M1s that we should be treating more seriously, maybe treating similar to F1s and F2s. And the 3 categories they targeted were Article B, so the offenses against persons, so assaults and rape, things like that. Megan's Law offenses and violations of the Uniform Firearms Act. So those 3 categories would be, we should be looking at those and thinking about identifying F1s or even, F3s or even M1s that we sort of bump up into the F1 and F2 category. And so that's exactly what we did. We went through the whole list, and for those 3 categories, Article B, Megan's Law, and VUFA, we identified all F3s and M1s and we treat those as F1s and F2s. So they come up into the second category. So we have crimes of violence and murder, F1s, F2s, and then F3s and M1s if they're in those chapters of Title 18. And then the other two categories are all other felonies and all other misdemeanors. So we come up with 4 categories of offenses. And then the prior record score just links to that. So again, taking that rule where we just look back at all prior convictions, identify if there's one or more than one of those, then how do we apply that to our matrix, to our categories 0, 1, 2, 3, and 4? Well, that's what we have on this column where it has prior record score values. So for a crime of violence, so if you look down through the list, and I think on page 2, Ryan, if you page down on page 2, you'll find some COVs. So these are in the crimes of violence category. Yeah, just paging down to the next page. Yeah. So if you see the COVs there, like murder 3 and so forth, that would be a crime of violence. If you look over to the right-hand column, you'll see the notation is 344. That means for a first prior of murder 3 or anything equivalent to that, so anything in that top tier of a crime of violence, you would be in prior record score 3 category. And for a second or subsequent, so second, third, or any other one, you'd be in 4. And 4 is Reebok. So if you look, and I know it's hard to shuffle all these various things, but in the matrix, we have 0, 1, 2, 3, and 4 for the prior record score categories. So this means if you have any prior crime of violence, the first prior record score category you're landed is 3. And if you have 2 or more, you're in 4. So that's somewhat consistent with our current policy in terms of Reebok is reserved for someone with 2 prior crimes of violence and a current crime of violence, sort of a 3 strikes rule. But this expands on this because this says anyone, you don't have to have a current crime of violence, anyone with 1 prior crime of violence is a 3, and 2 or more prior crimes of violence is a 4, which is Reebok. And Reebok allows the statutory limit. So that's I think that's a response to concerns about repeated violent offenders, pattern behavior, and about adjustments that we're making to the prior record score to reduce the impact of prior record score, but recognizing crimes of violence and murder as priors are different and categorically are treated differently. So that's the first category. That's so 3, 4, 4. First prior of that puts you in prior record score 3 category. Any subsequent caps you at 4. If we move to the second category, then the
Can I
second,
ask just
oh,
a
sure.
quick break?
Yep.
So if somebody has 2 aggravated assaults out of 1 incident, so they
Mhm.
serious bodily injury to 2 people in 1 incident, they are convicted of both. For prior record score purposes, is that a 3 or is that
No.
4?
We look at all individual offenses, all convictions.
So if
That would
somebody
move
had
you to
1
4.
incident. Okay. The only reason I asked it is I guess that could have happened when people were sentenced to 4, but I got the idea of Reebok is somebody who's done it once and now they've done it again. So I was just curious how that.
Yeah, this runs, you're right. I mean, for 3 strikes, you're right. That's the definition of 3 strikes. For prior record score, again, these are voluntary or advisory guidelines, and we're just setting a stage, and we're saying that's for the typical case. And the typical would be that there would be multiple incidences, but
Sure.
maybe that's not typical, and the court could depart from the guidelines or mitigate. Keep in mind that the lower end of Reebok is still lower than it used to be, right? So we're still, but what it does is it includes the statutory limit as Reebok always
Sure.
did.
Well, and also I would say that it doesn't seem like you should get it. If discount because you happen to commit. So the
Right.
fact that they took 2 victims and 1 incident, I just wanted to clarify to make sure I was understanding the
Mhm.
calculation. So thank you.
Sure, thank you. So that was the first category of prior offense, crimes of violence.
I apologize for interrupting. Do you mind if I ask a question real quick?
Oh, please, sure.
Mark, so just sort of foundationally here, has there been any material changes in the proposed 8th edition guidelines since the special work session on July 28th?
Yes, exactly what we're talking about right now.
Okay,
So, so the key here is that I think in the proposal that was published in January, there was no carve out for these 3 categories for crimes against persons. So Article B for VUFA or for Megan's Law. There was no carve out for that. They were treated. We just looked at the grade of the offense, basically. The feedback during the public hearing was we should think differently about those 3 categories. And I think when we had discussions on July 28th, we did not have the policy developed then. We just agreed that we would treat offenses in those 3 sections differently. But I don't think we described it as applying that to F3s and M1s, because you could have taken those discussions as saying, apply it to any offense under that. And that would mean, M3s would be treated like F1s. So I think as we were looking through this and looking back at the testimony, the idea was there are M1s and F3s that sort of should be treated much more seriously. And we should put those in with those serious felonies. And so again, I think that is different, qualitatively different than either what we published in January or what we discussed more generally in July. So that's why we're spending some time focusing on how these definitions would work and how they would play out.
all right, I appreciate that. Thank you.
Good, thank you. So that's the top category, crimes of violence. So now the second category, F1s, F2s, and then F3s or M1s if they're in those 3 categories, crimes against persons, Megan's Law, VUFA. So if you look at the category, the next category we have, and Ryan, maybe you could go to the next page. And under voluntary manslaughter, I think there's some examples there of F1 offenses that are not VUFA, are not crimes of violence. And you'll see there that the category is 233. So basically, any F1 offense that's not a crime of violence should be in the 233 category. You can see some of them right there. So the idea here is, again, if you look at the matrix, if you have a conviction for that offense or any equivalent offense to that, your prior record score for the first one is a prior record score 2. And for a third or subsequent prior of that level, it would be prior record score 3. So you would not move to 4. 4 is reserved for crimes of violence, but you would move to 3 with 2 prior convictions for an F1, F2, or those designated F3s, M1s. So that's the second category. And you can just think about that with any felony 1 or felony 2, and then add in these extra, these special F3s and M1s in terms of the starting point for the prior record score is 2, and then it moves to 3 for a second or subsequent. Moving to the third category, we've excluded basically the violent and serious felonies because we put them in either crimes of violence or that second category we just described. So now every other felony that's left is in the third category. And so if we look down at felony 3s that are not in those categories, and
we might have to move back a couple pages. But if we get to a felony 3, like for theft, a felony 3 for theft would be 223. So for one prior felony 3, you would receive a prior record score of 2. For a second prior for that level of offense, you'd also be in 2. And for a third or subsequent prior, you'd move to 3. So that's for any other felony, and that would include drug felonies. And then the fourth category, the final category, would be any misdemeanor. So we exclude the M1s that went into that second category, but any other misdemeanor would be in the final category. And you'll see, a bunch of these for misdemeanors, and this would be 112. So any prior misdemeanor gives you a 1 in the prior record score. A second prior misdemeanor keeps you at 1. A third or subsequent prior misdemeanor puts you at 2, and you're capped at 2. So it's we can automate the process. We base it on all convictions prior to the current offense date. We don't have to worry about concurrent consecutive. We don't have to worry about the grouping of offenses. We don't have to worry about any of that stuff. And for out-of-state offenses, we can apply the same rules because we know what the maximum penalties are based on the grade. It might take a little extra work to figure out current equivalent for an out-of-state offense if it's a crime of violence or if it's in one of these chapters, but people do that now. So out-of-state offenses are always a little bit more difficult, but we have a method to do it. But I think this simplifies it. I think it's much more proportionate. And what we found from the research, and Matt and Brett have done work on this as well, what the research finds is the biggest difference in prior record scores between 0 and anything. And so the idea of having a 0 prior record score that's a true 0 is something we heard about for years. And the research actually supports that having no priors is meaningful as opposed to having any priors. So putting someone with even 1 prior misdemeanor in a 1 category is consistent with the research. And remember, and this is quibbling a bit, but if you get ARD, it doesn't count in the prior record score. So there's that sort of avoidance there. And we will talk later about the lapsing policy. So over some period of time, there are certain offenses that may go away, and maybe misdemeanors would. So although we talk about it as being a pure 0, like an asterisk by it because ARD doesn't count, and there may be some lapsing of offenses, 10 years out or something like that. So anyhow, so this is, I wanted to give you that. And I think the advance here is, of course, we've made some policy choices as recommendations to you, but I think, this gets to simplifying it. I know I had to go through the explanation of that, but I think just with that being, if you just look back at all priors and you look at the grade of the offense and what the OGS, the prior record score assignment is just based on that 223 or 112, seems to me it's pretty straightforward. And so that was, we're hoping that we're checking the boxes on what we said were guiding principles. Automate it, simplify it, make sure it's consistent with sort of the research in terms of what works and how it works, and just that it can be understandable to the field. So anyhow, so let me pause there, take any questions or comments.
What conviction and sentence for current?
No,
offense?
just convictions. And that's one of the problems right now, because our policy is so complicated and it depends on concurrent consecutive. Right now, under the policy, you can only consider in the prior record score offenses for which you have a sentence, because you don't know if it's concurrent or consecutive. So we have that carve out, I think, in our language right now. So this eliminates that. We don't have to know about sentence, which is actually consistent with our definition in the guidelines, which is what the priors you can consider are any convictions prior to the commission of the offense. But then with our prior acts of our policy, we need a sentence so that we know if it counts or not, so.
What was talked about is like the commission and conviction before the commission of the current offense, and then a sentence for that prior commission before the sentence on the current conviction. Because
Right,
you have those moments in time where individuals are, I mean, if they're offending or processing of the cases, really close and they're not sentenced yet on this one. It'll be a week after you sentence them on the current one, you can't. So anyway, point, I think well taken is complicated.
and Judge, I remember many discussions with you about this stuff is getting so complicated. It's like,
I like the simplification.
right, yeah, so we think, we think this is simplification, but we think it's principle too. We think it's tied to what we heard about, what should matter with criminal history and how you treat it and weights. And what we heard was, criminal history should matter when there's, threat to the community, like violence and harm. And I think this tries to capture what we heard during public testimony about, treating those things more seriously and not just looking at the grade of the offense, taking into account the act that occurred. Any other?
Okay, so first of all, thank you, because maybe it's just me where the light bulb kind of went off. That becomes much more clear now as I go across and look at all of these. And my question would be, if we're looking at individual offenses and we see assignments and we think that sort of doesn't make sense, or I would bump that up, do we just go through the list before December and reach out to you, or?
Sure. You can do it that way. And what we can, I think we provided, or we can provide sort of those rules, those definitions for the 4 categories. So I think where we found that maybe it's you could get into a lot of tedious kind of work is looking at like Article B, which covers a lot of offenses, a lot of chapters of statute. And you might look at that and say, well, this specific M1 maybe shouldn't be included. But that then takes us towards this very complicated way of coming up with specific assignments for each and every offense. And then it's very difficult. It's not impossible, but it's more difficult to automate that. So trying to come up with categorical approaches to this, and then building into the language of the guidelines as we do now, the authority for the court to recognize when, it underestimates or overestimates the criminal history of the defendant. Like right now, we say that, if someone caps out because they have, 7 or more misdemeanors and they cap out at 3 in the prior record score, we say to the court, yeah, if the person has 1,000 prior misdemeanors, you can depart above the guidelines. And if someone has priors, but they're very, very old, what we're thinking about in terms of lapsing, we say to the court, that's the guidelines, but you can depart below the guidelines because you're recognizing it doesn't have the weight that typical cases would. So I'd ask you to, when you're thinking about or looking at these, just think about categorical approaches. So if there were ways that we would define categorically things like take out chapters or something like that, but we need to keep it manageable and sort of streamlined. So that would be the only suggestion or hope, I guess. Any other comments or questions on the prior record score, at least that part of it? Okay, so you have a big list there, and it could be a bigger list, I'm sure, but I wanted to make sure you had that. Okay, let me move on to a couple of other things that are in the prior record score or in the materials. So the next thing is the matrix, and I know Jadine just handed out copies of the matrix, and so I will I'll talk about a couple of the things with this matrix. And I think under the copy that was emailed to you and that's handed out, there's one, I think, one or two noticeable differences. So the first thing is, under the matrix that was discussed during the July meeting, if you look at OGS 1, prior record score 4, or REVOC, that was, in the earlier version, was still considered level A, restorative sanctions, with, I believe it was RS to 6, with 1 month of restorative condition or restrictive conditions available. What we've done is add that to level B and make it a 12-month of probation. And that was in recognition of people saying, even for an OGS 1, at some point, you should be able to order, probation as a standard thing, and maybe you should be presumptively a probation, not allow for guilt without further penalty. So this just sort of takes into account that one category and dropping it down. I think the other thing, and this is something for the commission to consider, but Ryan and I have done a couple of regional meetings, and we purposely did the first couple of them in more rural areas of the state where individuals might not have been involved in these discussions. So we did one in Jefferson County that had people from maybe 3 or 4 surrounding counties, the administrative unit. So we had discussions there. And then we did one in Washington County, a little larger group, but again, sort of a regional meeting there. And a lot of good discussion and feedback. And one of the things that we heard, especially from more rural counties, was some concerns about level A, about the idea that they might not have, like, it might be difficult to order community service or fines or something like that without any kind of supervision. They don't have a standalone community service thing, or, they just can't like plug someone down and hope the work's done, that they need like a little bit more assistance there. And we talked about, how could you strike a balance on this? Because clearly there's some of these offenses that in more urban areas, there is the interest, we heard in Philadelphia about the interest of trying to have some of these like standalone sanctions, like community service or fines or whatever, and just to deal with big numbers of relatively minor offenses. And we talked about this yesterday, sort of akin to MDJs handling these matters. And so we didn't want to lose the ability to target lower level cases to an A where there could be those standalone options without supervision. But we also recognize that, in rural counties, that could be a challenge. So how do you strike a balance there? Well, what we're suggesting is the recommendation should stay that these are non-probation sentences, but we should provide some latitude to the court in terms of a mitigated sentence or an aggravated sentence to add in short periods of probation. And so what we suggested before, for aggravated mitigated, we had plus or minus 25 hours of community service as the sort of adjustment. But we've replaced that with 3 months of probation, so that in those cells where we're recommending up to 6 months of probation as possible, that could be reduced down to 3 months. But in those cells that are just RS, as needed, the court could add up to 3 months of probation. And because the aggravated and mitigated ranges are considered part of the guidelines rather than departure, it can be part of the sort of process of the county that could be, I think, could be easily implemented, and could be part of negotiated pleas, because that was the other thing that they were saying. There's a lot of these negotiated pleas, and they want to stay within the guidelines for a negotiated plea. We think this accommodates that. It might not be perfect. They might want more, but Philly would want less. And so, we just have to sort of figure it out. But we think those two things would accommodate. We add in the 1-4 for level B for probation as sort of a presumptive cell. And then we add in the 3 months of aggravated mitigated time for level A. So I think those are the only two changes, Ryan. Were there any other? Okay. So with that, then we have this matrix that takes into account 30 instead of 36 typical categories for assignments. We have, I think we've held to, pretty much what we talked about before in terms of, I think as compared to what we published in January, we have just a little bit broader ranges. I think they're a little bit more proportional. In July, we talked about compressing a couple of things, like for probation, we removed the 30 and 36 month probation cells, and we capped it sort of at 24 months. That was a recommendation from the County Chiefs Association. It doesn't mean courts can't give longer probation, but it sort of targets on those shorter periods that are consistent with some of the research. In some of the county jail sentences, we again collapsed some of those and expanded the range a little bit. I think Judge Marsco and others talked about giving a little bit more discretion within the recommended ranges. And then, as I said yesterday, we have as the F1 omnibus default 22, OGS 22, so a 60-month base for that. And then we have as the super felony, the max of greater than 20 months, 20 years at level F, 27 and 90 month baseline. And so one thing that we were thinking about was in terms of going back and rules that we would apply to bring back to you in December. I think felony 1, super felonies would have a statutory max of greater than 20 years, but not life. Maybe our default would be the 22. And then those offenses that have a statutory max of life, we would have as the default 27 to put it in that category. It's, and again, 27 we want to reserve for those that are super felonies, but that doesn't mean every super felony has to be there. So at least in terms of us plotting all this out to give you a draft to look at, those are some rules that we thought we could apply that provide some proportionality, take into account the rules we already have in place. So with that, let me take a break, see if there's any questions on that before we move to some final issues. Sure.
So question on, for example, we're in B.
Mhm.
So let's just slide over to, if your OGS is a 4
Mhm.
and your record score is a 2.
Yep.
So we've got 18 months probation, and it says 1 and 2 months restricted conditions.
That's right.
So when I'm sentencing that, then I looked up to another example in, let's just say in D.
Mhm.
So like, if OGS is 13,
Mhm.
and we go over the same, our record score, so we have 20 to 26 months restricted conditions.
Mhm.
So my understanding is, when you say 1 to 2 months of restrictive conditions, are you saying that the guideline range would be probation with restorative sanction or with restrictive conditions for 18 months, the first 1 to 2 months of which you impose something like an electronic monitor? Because my understanding is I can't give, it wouldn't be 18 months of probation, 2 months of which is restrictive conditions. I mean, my understanding of how we had to change the language when we went away from CIP is I can give somebody county probation and I can give them conditions, but I can also give probation with restrictive conditions, and we articulate what those are because there's a set definition of what restrictive conditions constitute. So I'm just trying to say, for when I am putting this to a sentence on record, what is the difference in terms of how that looks? The recommendation of whatever 20 to 26 months restricted conditions versus 18 months probation with 1 to 2 months of restricted conditions.
Okay, I'm going to start and then I'm going to ask Ryan to talk about this. So I think in the first one at level B, where we're talking about a 18-month probation recommendation with 1 to 2 months of restorative conditions. The technical, the language used to do that, I'm going to defer to Ryan on. But I think the concept is similar to CIP, that it was 18 months of probation is the recommendation, of which 2 months of that probation would include restrictive conditions. So whether that under the new formula would require a 16-month probation with standard conditions and 2 months of probation with restrictive conditions, or it's 18 months of probation with 2 months of house arrest or whatever else. I think the latter is what it is. I don't want to get hyper technical, but that's, and Ryan, please.
Sure.
Is that your understanding?
18 months, and then you articulate the period of the restricted condition. So it'd be a recommendation from the commission to say, if you judge wish to include restrictive conditions, the recommendation would be 1 up to 2 months of that period of probation.
Okay, so would my sentence, because my current forms, based upon all I learned here, indicate there is a check mark for probation, and there's a check mark with probation with restricted conditions. So in the B, am I check marking, if I wanted to impose, let's say my imposition is inpatient treatment, or let's say it's just electronic monitor, that's easier. So if I'm following these guidelines, I would say 16 months probation and then check mark, or it's 18 months probation with restricted condition the first 2 months. So then when I go up to number 13, and I have 20 to 26 months, I'm going to sentence, let's say, the bottom of the standard. So I'm 20 months probation with restricted conditions. I impose my restricted conditions, but that may be some section of electronic monitor and then some other things. So
So I think, and Mark can jump in with me on this, and this goes back to like old, like in the 90s CIP and these trade-offs. So
Right.
under level D, the recommendation of 20 to 26 months is talking about confinement, but the court has the opportunity in that level in lieu of county confinement. Let's say you could sentence the person to probation that includes restrictive conditions, and then the way we talk about that currently, and I think we would replicate that here, would be you would have a day-for-day trade-off to be within the standard range of guidelines. So you would have, say, some period, like 5 years of probation, for example, and then 20 months of that is a restricted condition. And it could be any number of restricted conditions that you choose.
Yeah, the only qualifier on that is, I think we retain the same rule we have right now about drug dependent offenders.
okay, so I thought, and then, so then the other question is, I would still need to make them reentry eligible.
If you wanted to release them earlier than the mid and you weren't using probation. So let's just think about the current practices and we apply it to this. So you have a minimum sentence range of 18 to 22 months or whatever it was, or 8, whatever it was. So under the current practice, we say, here's the sentence recommendation. First, if the court wants to use restrictive conditions in lieu of confinement, the first question is the person drug dependent? If so, you do an assessment, determine the clinical recommendation, and then the trade-off is either that clinical recommendation to treatment or the confinement sentence. And then if during that first inquiry, you find out the person is not drug dependent, then as Ryan said, it's a day-to-day trade-off. And then there's a lot of different ways you could do that, right? You could say, I'm going to do a split sentence and I'm going to give a 6 to 12-month sentence that takes care of 6 months of confinement. And I'm going to do a consecutive, probation for whatever and have restrictive conditions. Or you can do, here's probation and it's an entire 12 months of restrictive conditions. So, there's a lot of different ways you can accommodate the restrictive time, the confinement time. Other questions?
So just so I'm clear on this.
Sure.
So Ryan, so what you're saying, so use the judge's example, 20 to 26. So you're saying you could sentence 20 to 40 and then probation with restrictive conditions in addition to that, or 20 months, say at the bottom end, would be the restricted portion of the probation,
Right.
correct? So they could be incarcerated in the state correctional institution?
No, so just think about, you're choosing, we'll give you 2 alternatives to choose from.
Yeah.
If we start with confinement, the recommendation is 20 to 26 months at the minimum. And you say, this person's a good candidate for probation with restricted conditions. And so you're going to use that in lieu of county confinement. So let's just take confinement off the table, keep it simple. Sentence the person to a period of probation, 5 years, we'll keep it at 5 years. And then because the commission's recommendation is for a confinement sentence, and you're using probation with restricted conditions in lieu of it, what Mark talked about is we have some rules of the road. Drug and alcohol dependent, as Mark mentioned, or if not, then we have this day for day trade-off where you can do restrictive probation with restrictive conditions here. You just have to at least do a period of those restrictive conditions would be 20 months up to 26 months to sort of comply with the guidelines.
And not necessarily compliant. Could
Right.
be, could
So
be,
you could fashion and say 5 years of probation with restricted conditions, and then, the first 20 months will be served on in-home electronic monitoring, or the first 12 months would be in-home electronic monitoring, followed by some other part of it.
but could any part of that be incarceration?
It could.
But if it's 20 months, then it's a state sentence.
Well, and here's one of the things, I think we got off on the wrong track by starting with level D as the focus, because remember, no offense, Judge,
I'd like to
but-
say it was A and.
No, okay, but so remember, our current policy focuses on level 3 and 4 as allowing this trade-off, right? But under our current policy, 3 and 4 are sort of the, it's county jail sentences or the lower tier of state prison sentences. It's not typical state prison sentences. It's the understanding that, there's some of these cases that could be housed locally. So we're not talking these huge minimum terms that we want to trade off with restrictive conditions. We're trying to think of, sentences that are comparable to county jail sentences that you're using restrictive conditions either in lieu of part or all of it. And that's how our current policy works, and that's how it works with the treatment alternative. So when we get up to level D and we start to get into these, big minimum term things, it seems odd that we're talking, 20 months of restrictive conditions, because the general, our general take over the years was there's a limit to how long you have someone on something like house arrest or electronic monitoring. And it's probably, 12 months or something like that. It's not 20 months on electronic monitoring. So that's where you just have, I think we have to be careful about using level D as our example.
But I think the problem is we've narrowed, we have these narrower guideline ranges now. Now I look at this and I'm gonna have, a defense attorney arguing for probation, basically, albeit
Paid
with
for the electronic.
with EM
monitoring.
and house arrest, when the guidelines are saying state sentence to, 20
Right.
to 26. That's a huge range.
Right. And I'm glad actually you both raised this, Judge. I won't give you total credit for looking at D, but so the question is, should we be removing RC from all of level D, from part of level D? Is because I see what you're saying is a concern. Our focus was to make sure it was on county confinement, and we have that there. If on state confinement, it's an all or none proposition, then, we can remove it from all of that. If you think there's like marginal areas, we can do it. The reason we put it in there was that if you look at the current guidelines, level 4 of the current guidelines is sort of like that D. And we allow it in level 4, even though it's not used a lot, but we allow the trade-off at level 4. So we're trying to develop this sort of consistent with our current guidelines. But we never put RC in the current guidelines. We just said level 4 allows for a trade-off. Because remember, it's not always about a day-to-day trade-off for restrictive conditions. It's the idea of using drug treatment in lieu of incarceration for those individuals.
So I think I already know which attorneys are gonna come in, and they're gonna have people with much more serious offenses who are paying to be on electronic monitor while somebody below them is sitting in jail. I just think,
So how
and
about
I
if
think when
we,
you spell it out, that is bad.
how about if we remove RC from level D, but courts could always do that as an aggravated or a mitigated sentence in terms of that trade-off.
I mean, how many people
There's no
do that
prohibition.
trade-off? I don't, Judge First and I were talking last night, we're here and we're plugged into some of this, but how much does that actually happen? I'm sure
I
a
think
lot of
it's
my
whatever
colleagues
is
don't even know about
negotiated.
it.
I think it's whatever is negotiated. And I think at the lower tier of level D, the, 12 to 18, 16 to 22, there's some cases, but I think it's more about drug treatment. I don't
Right.
think it's, I think it's that someone's drug dependent, we're gonna put them in treatment in lieu of incarceration, because the alternatives would be to send them to state prison and get them into state drug treatment program.
Yeah, yeah, but I mean, if you take the drug treatment aspect out of it, are people doing this trade-off?
But DUIs.
Yeah, yeah.
Yeah.
There you go. Yeah.
But so anyway, the reason I mentioned the trade-offs, it's in the guidelines, and that's sort of what we're talking about, but appreciate that's a big number. I'm not so sure that we see the trade-off as much, but when Mark's talking about, we see a lot of drug and alcohol
Sure.
violations, and then of course DUIs, that is the big driver of anything. We have DUIs that are level 3, level 4 that occur about.
So then stick an asterisk, and the asterisk to say it's to seated code section number for anybody who bothers to go there. Because
Well, how about
I
if we
think
just,
this is open to mass.
yeah, how about if we
Because
just
a lot of
remove it?
people are just live by this, yeah, and I'm gonna say even,
Well, we love that.
I'd be willing to get you,
You're living by
but
it.
just, I'm just gonna see you not agree, like beyond this, how they're not flipping through 42.
Yeah.
Sorry,
So as, oh, come.
and I just, if you polled judges, and maybe I'm wrong, and you ask them what RC stands for.
Yeah.
What percentage of judges do you think are gonna know, or like, do you think will say like, oh, RC restricted conditions?
Yeah.
I mean, I know because I run our recovery course and we use it a lot, for our intermediate punishment program.
Yeah, hopefully the 4 of us, the 5 of Barb's on there too, we all know what RC stands for, but
Yeah.
I agree.
broadly.
Yeah.
I'm saying if you pull it to help explain CIP and what happened
Right.
to it and what it now is, it's complex.
Okay,
It changes, so,
we
I
will
just think we need to
remove
clarify
RC
what
from
RC
level D.
and then we need to clarify what RC is or how they use it in some form.
Right. Well, but first step, we'll just remove it
Yes.
from level D. We'll retain it in level C. Clearly we'll be, this is a new concept and we're trying to blend it in. So we get that. I think Ryan's point though is a good one regarding DUI offenses.
Mhm.
Because under the proposal we have and with the new legislation, you're going to have those 1-year DUIs that are 4th or 5th subsequent kind of offenses. We start at an OGS, the sort of the baseline for the highest tier, I think, is an OGS 13. These are the new felony 3 or felony 2 offenses. So you're going to get that lower tier of D to start with. And then what we're saying is, as an enhancement, it could move up 2 steps. If you have a 6th offense or whatever, it could be an OGS 15 for a DUI, which is a felony 2 offense. So again, we can remove the RS, and that's not a problem, or RC, that's not a problem, but it's just recognizing that that's where DUIs are, as felony 2s. for
But if
those
you're a
repeat
5th or 6th
circumstances.
event DUI, why?
Well, no, I totally get that. I'm just saying, I'm just pointing that out, that that's where it would fall in the new, main list. So we'll remove RC from D. That's the takeaway.
Right, we can still do it.
You can still do it,
Yeah.
and we can, in a commentary and everything else, we can go into much more detail of that.
But you said it exists now.
It does,
So
it
people
does.
want it, yeah.
But I think, Mark, correct me if I'm wrong, historically, when county IP came in the 90s or whatever, it was mostly, the trade-off was at a county sentence level.
Absolutely, you're absolutely right, but keep in mind, at that time, the 2 to 5 maxes could be served in the county jail too. And so that's why we added in level
I got you.
4, because we said, well, there might be those, for whatever reason. But I think that I'm really glad this issue came up, because I think this is an improvement to remove it, recognizing courts can do it if they want to, but it would not be typical. It would be an exception. And the exception may be more often for treatment in lieu of incarceration rather than this day-to-day trade-off to like house arrest.
Outside of DUIs and drug treatment, do you see many sentences of probation with restricted conditions?
Well, we saw about 10, well, that's a good question. A lot of them were for DUI. But I think in our data, I think it was 10 or 15% of cases were getting CIP in the old days. But I assume like 75% of those were DUI. So it's not a lot, but simple assault.
And doesn't it impact funding? Because like a lot of things that could just be probation, but your person needs some kind of treatment or something, I'll impose probation for conditions.
Right.
And then impose that, but I believe it impacts
Yeah.
our ability to receive funding, which helps us to keep those programs.
I mean, playing by the rules is, that's the one thing. Okay. Any other suggestions or questions about the matrix?
A 10-second comment, just that the reason I know we already decided, so I'm glad for that, but like you said, they can still do it, but I always think when you say these guidelines are typical offenses, typical offenders, then when they are those unique circumstances, they still have that authority, but it's not a fallback, and it's not an ability for things to be.
No, great point. Great point. All right, thank you. So, so we'll incorporate those changes that were discussed. So here's a number of other issues that I just wanted to put on the table, and then we're going to switch to other guidelines. For lapsing provisions, during the July 28th meeting, there was some questions or interest in trying to figure out what other jurisdictions did. So Jordan in Brett's unit prepared a summary of juvenile adjudication and adult conviction lapsing policies in other Pennsylvania jurisdictions. And so we have prepared that document, we posted it, but I know it wasn't emailed to you a couple of days ago. So we will make sure we email it to you. But it's just, I think it's helpful to look at, but I think as you'd sort of expect, every state's different, and it's hard to like cut and paste what other states are doing into ours, but it does get to this sort of general policy discussion about how to lapse and how does that lapsing apply. And let me just sort of remind you of some of the general concepts that we've been talking about, and we'll just assume that unless you have objections, we'll build these into whatever draft we're doing for the December meeting. So on the juvenile side, a couple of things that we've discussed and were part of the July 28th discussions. Number one, the Juvenile Court Judges Commission suggested that for consideration of juvenile adjudications in the prior record score, we should increase the age from 14 to 16. Understanding that if anything is certified or direct file, they're going to be criminal counts. We have those as convictions, but for juvenile adjudications, moving the threshold from 14 to 16 was one of their suggestions. Consistent with brain science and all that other kind of stuff. The second suggestion was, and something that we put in the proposals and talked about in July, was to have some sort of age-based lapsing provisions for juvenile adjudications. So the thresholds are basically 21 years of age, 25 years of age, 28 years of age. And the idea for 21 and 25, where we look at basically prior lesser offenses like M1s, F3s, would just lapse at 21 years of age. We wouldn't look at law-abiding behavior, it'd be treated like DUI, like a look-back period. But at age 21, prior lower level juvenile adjudications would be lapsed. At age 25, everything but crimes of violence would be lapsed. And then at 28, we would start consideration of crimes of violence, but that would require 10 years of law-abiding behavior. So for crimes of violence, you'd have to have 10 years of law-abiding behavior from the last adjudication or conviction. So it would be a 10-year gap period. That would be gap. But the other provisions would be decay periods for juvenile adjudication. So that's consistent with what Judge Tucker's raised as far as concerns about even considering juvenile adjudications. The Juvenile Court Judges Commission raised that same concern, but like an accommodation here was, let's increase the age at which we even consider juvenile adjudications, and then let's have some sort of hard breaks. And the exception would be these violent offenses. Some of those, a number of those might have been transferred over anyhow, but if they remained in the juvenile system, we treat them differently, and we make it a law-abiding period for 10 years. So unless there's objections or other suggestions, we'll just keep that in what we have in, which we provided in July, and we'll provide that for you in December for your review. Yeah, sure.
So, I always just keep going down the road, of hypotheticals,
Yeah.
they're never ending, but, so you have a juvenile with a VUFA charge. Right. At 24, he commits a robbery. At 25, the VUFA charge is going away.
It is. But we have the same language as we talked about earlier.
For
that
prior
the court-
record score.
For prior record score.
But would it impact the prior record score anymore anyways, if they get that offense when they're 20, whatever age you put them at, 24? So if at 24, they commit. That's
So,
just
yeah,
an offense.
it would be there at
For the
that
24.
point, but if a year later, it would not. You're right. If they were 26 and committed a robbery, the VUFA from there as a juvenile adjudication would not count under policy.
And in the realm of the absurd, like a VUFA every year from the age of 16 to 25, they all go away at 25.
They do, but two things. Number one, the language that we have right now, we can build into this is that the court can always consider those things. I mean, what we're trying to do is set up rules or guidelines about typical cases. And so the question is that typical for juveniles? What we heard in the research was, I think, 6% of our cases even have juvenile adjudications at all, right? But if the person is committing a VUFA every year up until 25, all the adult ones count. It's just the juvenile ones would go away. So from 16, 17 would go away, 18 it would count. So, I mean, I get your point, and we're thinking that, in the juvenile court, for serious juvenile matters, there's, direct file and transfers, there's certification. If there's, for these kind of offenses, by 25, which is where the VUFAs would be, they'd be that just less of crimes of violence. 25 would be the point of time. So you'd be able to see the criminal history from 18 to 25. That's 7 years of, if they're continuing to offend, they're building up a criminal record. If they haven't offended at all during that period of time, that's what we're saying, then, those juvenile adjudications would go away and they wouldn't count the prior record score.
And there's some M1 VUFAs, so they go away at 21.
They would.
So you're 17, you get a VUFA charge. Now you're 21 and you commit armed robbery. The prior VUFA is not part of your prior record score for sentencing guidelines.
And that's where that language in the guidelines, and we can look at that language, but it does say if the prior record score like underestimates the seriousness of criminal behavior or something, or overestimates it, the court can do it, which is just saying these are typical, and is that typical? Is there something about the offender that should or should not be
But
considered?
if we have specific language that says they lapse, then do we really think that a court can say we can still use it even though there's specific language that says it lapses?
Well, I think that's where, we have that right now, where we say what's critical is that you appropriately calculate the guidelines. So for instance, if there's a lapsing, you cannot include that in the calculation of the prior record score. It doesn't mean the court can't consider it, and that's the language we have now, that we say, that we recognize that sometimes these like macro guidelines underestimate or overestimate seriousness. And so we say it's important that you calculate them by the rules. And so that's where the lapsing thing would come in. So you couldn't like add it in even though we say it lapses. But once you've done that, if the court looks at this and said, there might not be charges here, but there's, there's something about that or that because this is a robbery and that was a firearms offense, that the court can do that. And we can look at that language and clarify it or expand on it, whatever else, but.
What's I forget, there's where's my bill once upon a time? There's a juvenile felonies make you a prohibited person until a certain age. But I forget what that age is.
There's a loophole.
I want to say it's like 25. I just wonder if that,
Juvenile adjudication.
you're 6105.
Possess, yeah.
But I think I thought that you were prohibited for a certain number of years. I thought it was until 25.
Is this under, is Luca?
Yeah, I think it's 6105.
I mean, if there's something like that, if there's something we can point to and we can do it as an exception, that's fine. That makes sense.
I don't know. Well,
Yeah, but-
at the same time, doesn't.
Okay. Yeah, well, the rep's looking at that. I think we have some people online. I think we're Attorney Marsico, so maybe we can open up comment there.
Mark.
Good morning. Yes.
Yeah, hi, guys. So can you explain the decay provision that District of Columbia uses? I'm just trying to make sure I'm reading this right. 10 years from expiration of sentence, prior felony convictions can be revived. I don't know what that means. And prior misdemeanors can never be revived. Do you guys know a little bit more about that? Because I mean, the one thing I think I would like to see, I know we're doing this gap, we're looking at these gap policies, but I think we should consider something along of decay for very old cases, but especially where I see cases where very old felony affect the guidelines disproportionately in a existing misdemeanor case.
Sure. So we'll have to look at the DC policy just to be sure, but as you mentioned, the big difference between decay and gap is that decay is just a timing of the matter, like we have with DUI. So 10-year period passes and it's no longer considered. Whereas as gap, it's some definition of law-abiding behavior. I think for purpose of the DC policy, when they're like recalibrating or revitalizing something, we'll check into that. But I think it sounds more like a gap policy than a decay policy. But we'll check with them. It could be that only certain things trigger the reconsideration or the extension of that period of time. But we will check on that and make sure we get back to you on that. But I think you raise a really good point, and this is one of the separations that we're trying to put in place between juvenile adjudications and adult convictions, and that is that there would be a sort of a presumption on the juvenile side for juvenile adjudications that it's a decay, because it addresses some of those other concerns that were raised about even using a juvenile adjudication. So we're using age, brain development, whatever else as reasons that might be the preferred policy. And I think, if there's exceptions, we should identify those. But I think, the easier approach to making it, age-based or something like that, I think it is better. I think when we get to the adult conviction side, at least based on feedback we had, there were a lot of comments that we should be more inclined to go with a gap policy, that they're law-abiding behavior. And I think to the degree that we have a separate policy there, it might be for misdemeanors versus felonies. That misdemeanors, we might think more of a decay policy, and felonies think of a gap policy. The thing about gap policy is it's just really difficult to implement. And so we're gonna have to just put the burden on someone. And if the burden's on the prosecution for determining the prior record score, it seems to me that if we're talking about removing something from the prior record score, so a lapsing of something, I think we're gonna have to put the burden of providing the information to the court on the defense. And, I mean, that's what we had in one of the earlier drafts. And I think, we just have to think of a way we have to set up rules and then figure out who's gonna be holding the bag on trying to prove it. But, that's sort of that's what we've been thinking about in terms of formulating policy. You have something?
Yeah, so, under 6105.
It's C7.
Yeah, C8, says person who's adjudicated delinquent by a court, blah, 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 blah. As a result of conduct which if committed by an adult would constitute an offense enumerated in subsection B, with the exception of those crimes set forth in paragraph 7, this prohibition shall terminate 15 years after the last applicable delinquent adjudication or upon the person reaching the age of 30, whichever is earlier.
Okay.
And I'm trying to think how, they're obviously different. I mean, this is establishing a crime, versus whether something's included in your guidelines. And I'm just trying to think of how this whole provision would interplay. So you theoretically have somebody who is committing a felony by illegally possessing a firearm, but the offense which renders them ineligible to possess the firearm is no longer included in the prior record score because it was eliminated when they turned to 25.
But it wouldn't be eliminated for that calculation.
No, it would still be a crime, but
Right.
it seems
Yeah.
inconsistent to me that we're gonna
Right.
say this is gonna count to make you a prohibited person until you're 30.
Yeah.
But it's not gonna count towards your prior record score after you're 25.
Well,
I just want,
and-
and I'm not necessarily saying that's a problem, I'm just sort of
right.
throwing that issue out there to think about.
But, I mean, one thing we could do is, if we're gonna do a carve out, let's think categorical. So do you include VUFA or do you include 6105 as along with crimes of violence in that top category, where you move to a gap and you move to, 25 years or 10 years of crime free or whatever, that you just say, it's crimes of violence and this provision or VUFA or, whatever other things. I think you can, let's look at sort of the three categories we came up with, like decay at 21, decay at 25, VUFA at 28, or COV at 28. Would we just put it in the fourth category?
Or move that 28 to 30 so that at least, well, you still be issued about the ones at 25. There's really two issues because you're gonna have the same thing occurring at 28. It strikes me as somewhat inconsistent to say that these aren't gonna, and I agree with, we need to have lapsing,
Right.
some type of lapsing policy. I'm not saying these convictions should last forever.
Right.
But I do feel like there should be some consistency.
Okay, and that's, I mean, so we can put some of that, we can look at some of that and try to, draft some things, because the reason we used 28 was 10 years from 18 years of age. And we were saying if someone was law abiding for 10 years from the last juvenile adjudication, that makes sense. That's sort of consistent. But I get for this, if there's something in statute about 30, maybe we move that whole thing to 30, or, we can try to look at some of these things, but, one of the fallbacks is, how typical is this? How often does this happen? And is this something that we ask judges to exercise discretion on, or that we build into the structure of the guidelines?
Can we find out how many 16 and 17-year-olds have juvenile VUFA for a period of time?
I think we can find that, because we did research before just to find out how many juvenile adjudications there are, period. Like I said, I think it was 6%.
Yeah.
And then there was a pretty low recidivism rate. I mean, it was just, it gets to be pretty small numbers, but I get it, you know, as policy, we should figure out what that is. So we can get back to everyone regarding, you know, specifics on food.
Now, there must be some issue with this statute because the DAs presented to me legislation to fix something about it that I think was a result of a court decision or something. So I don't remember what it was because it was several sessions ago, and I know that the bill didn't pass.
Yeah.
So,
Okay.
I don't think it was considered. So I don't know the current state of that statute either, not to be fair. There's certainly something about it that the DAs.
Well,
want to
look,
fix.
we'll talk offline. We'll see what we can come up with. And then, as I said, this is all directed towards providing all members with draft guidelines to review during the December meeting. And the idea then is, you know, we always have a, you know, Wednesday, Thursday kind of meeting. I think what we'll try to do is schedule a Wednesday 1 to 5 meeting as we did this time. But it'll all be about just looking through the draft that we've prepared for the 8th edition sentencing guidelines. And you'll see that there's other guidelines we'll give you drafts on as well. And trying to see if there's any kind of clarifications with the idea that during the Thursday business meeting, we would be looking for the commission to approve the draft so that we can hold public hearings in February, March, and then the commission would be positioned to adopt, if they wanted to at that point, those guidelines to submit to the General Assembly, which would put us on track for the January 1st, 2024 effective date of the 8th edition guidelines. So, we'll talk about some of these issues. Let me tell you 2 or 3 other issues with the sentencing guidelines that we've talked about and that we'll work on drafting and putting into the draft. The first was we provided previously some language during the July 28th meeting on concurrent consecutive policy. I think, you know, we said basically during a criminal proceeding or a sentencing proceeding, judicial proceeding, the assumption would be that sentences for lesser offenses would be sentenced concurrently, and the exceptions to that would be if there's multiple victims. If there's, I think there were a couple of other exceptions, multiple victims. Anyone recall? Okay, thank you. And we did receive an email from someone that had some suggestions about circumstances that we might want to have as I think it's multiple instances. I'll find it. Here we have exceptions include convictions for crimes of violence, proceedings involving multiple victims, and offenses for which consecutive sentences are required by law. So those were the 3 exceptions to the general policy. But again, courts can do whatever they want. It's just setting a general policy about concurrent consecutive. And then we did receive comments where the issue that was raised was, what if you have an incident where you have 2 sort of different kind of harms? Like someone's charged with assault, but then there's like distributing photos of minors or something like that. 2 like very different things that are in an incident. So, you know, is that typical? Was that, you know, whatever? Is that where the court would just say, well, here's an exception? Or so we'll have to see if there's some other language or exception that we should build in. But then we want to think about the other side of the equation. And it's not just when the General Assembly requires consecutive sentences, but are there explicit circumstances where the commission in the guidelines recommends concurrent consecutive sentences? And so I mentioned yesterday several provisions around trafficking and so forth, human trafficking that may be worth considering. So section 3011 and 3012, as well as section 3133, were areas where the commission may want to consider recommendations about consecutive sentencing. And on my list, So, section 3011 is trafficking in individuals. Section 3012 is involuntary servitude. And in both of those sections, there are sometimes convictions as well for rape, IDSI, or kidnapping. And in the statute, that's when there is a statutory max of life that's available. And in those circumstances, the commission is also supposed to provide an enhancement. So we have an enhancement in terms of trafficking or involuntary servitude about increasing the OGS. And then the question is, if you're convicted of both that offense and an associated offense of rape, should the commission be recommending consecutive sentencing? So the two separate harms are considered. We don't have to, but it's one of those things where, we're supposed to have some kind of enhancement, and we can do that either by just increasing the severity of that offense because there's an associated offense. We can do it just by a consecutive sentence, or we can do a combination. So that's just one issue that we put out there for consideration. We don't have to decide today, but I wanted to mention that. So the same applies to involuntary servitude as with trafficking. And then 3133 deals with sexual extortion. And so sort of the same kind of thing. There's usually associated other offenses. And the question is consecutive sentencing something that the commission wants to include in a recommendation? And the only reason I point this out in this context is if we're coming up with a general policy saying general things are concurrent except for these circumstances, is there something we want to put in the guidelines where we sort of exclude that, or we actively say no, consecutive is how we should recommend this, even though the court can do whatever the court wishes. So I just point those out. The other two areas about consecutive sentencing that we should keep in mind is one, the new DUI statute for third and subsequent DUIs. There's now an automatic requirement of consecutive sentencing. And for 3735, homicide by vehicle while DUIs, there's the if there's multiple victims, there's a requirement for consecutive sentencing. So those would be listed as exceptions to the rule. Right.
Mr. McKinson from Senator Street.
Oh, yes.
Hand raised, and I just want to make sure.
Sure, please.
Hey guys, thanks. Fortunately, my video is not functioning. I apologize for that. But I just wanted to ask, in terms of lapsing of juvenile records over a 10-year period of good behavior or no, I guess no bad behavior, what are we talking? Is there any criteria? Like, are we talking if they shoplift, that counts as not, if they over a period of 10 years they had maybe like a jaywalking or a shoplifting thing or something, would that disqualify them from that?
Right, that's a great question. Under the current lapsing policy that we do have for juvenile adjudications, we exclude summary offenses, and we exclude, I think, the first M3. I think that's how we do it. So we do have that as a carve out. So in your instance, if there was a single M3, that would not undo the lapsing provision. But otherwise, any kind of misdemeanor or felony would trigger or would cease the lapsing. And so that would be a question as well for the commission about how do you define, a new conviction offense? Is it any misdemeanor or felony? I'm sure we exclude summary offenses, but is there, how do we look at that? So thanks. That will be something that we'll return to in December when we look at the draft.
Hey, thank you. Appreciate it.
Thank you. So let me close with two final things that were raised during July. And again, if there's any comments as staff works on the draft. The one was the aggravating and mitigating factors that are listed. So we provided in the document a list based on what we heard during public hearings and what we had provided in advance as far as some of the adjustments that we removed, but we embedded those into a list of aggravating and mitigating factors. And I think during the meeting, some members had raised some questions about, should some of these be included, and others suggested maybe there were others. Now, I don't think I received any comments, so we'll keep looking at this list. We'll look back through the public testimony that we received and any kind of comments that you have. We'll also look at the reasons reported to the commission for aggravated and mitigated sentences and see if there's anything that changes in this list. But this is the list we have right now. And unless we get other information, we'll be moving through with this list and put it in the draft that we provide to you. And then the final thing was, I mentioned yesterday that we talk a lot about problem solving courts, but we really don't have anything built into the guidelines regarding the use of problem solving courts like we do for clinical assessments and treatment as a trade-off at level 3. So if there's any suggestions about ways of incorporating problem-solving courts or risk needs responsivity assessments, things like that into the guidelines, let us know. We'll take a shot at, especially at level C, I guess, which are county jail sentences, to see if there's some language we can put in there to broaden the consideration of problem-solving courts.
And D with the DUI laws.
And DUI, yeah. So we'll take a look at that. But as I said, we're on track to get that draft to you before the December meeting. Then we'll spend that Wednesday of the December meeting just reviewing it in anticipation of it being approved on Thursday so that we can have public hearings early next year. The other two areas, so we're done with sentencing guidelines now. Thank you for your patience. Got through that slog. What's that? Uh-oh. Go ahead, Judge.
Just a suggestion
Sure,
for the
sure.
thought.
Please.
When you were talking about the concurrent consecutive,
Yeah.
do we carve out sections where we recommend? So as of now, we're saying recommending concurrent, unless there's multiple victims, crime of violence, and where it's consecutive like by law. Instead, do we want to think about the concept of when we're making that list of times where there's exceptions or any other like overriding facts where the public safety necessitates a consecutive sentence, something like that, which is sort of the catch-all where if we can articulate what that is, we put it consecutive and then we don't have to add on consecutive, but it spells out there are other times, because those facts where you have a kidnapping and then someone goes to the gas station and commits a robbery with the victim in the car, like, so those are things where you would think, well, that sort of necessitates a consecutive sentence. So
Sure.
anyway,
Yeah.
just that was a thought.
No,
And
thank
then
you.
super
That's
fast is you'll be, I'm assuming, sending out what we're reviewing. We will be reviewing for the Wednesday meeting prior to the
In
Wednesday
advance,
meeting.
that's correct.
So do we want to at least encourage submissions of written suggestions and proposals prior to meeting together on
Yeah,
Wednesday?
that would be great.
So, okay,
That would be great.
that's
Absolutely.
my recommendation.
So we'll try to, there's always more work than there's time, but we'll try to get the draft out to you a couple weeks in advance, maybe, the beginning of maybe, early maybe in November, like before Thanksgiving. So
None of us are
sometime.
looking until 2 days before. so
I
you-
know,
but-
Yeah, but the thing is, it gets us off our plate. And then if you do actually look at it, and you have some specific issues, you can get them to us and we can work on drafts of changes.
Yes, I may have more
Yes, I'm sorry, Judge Dowling.
That's right. Right, he's. He's Sunday.
Okay, quick question. So, Mark, under aggravated and mitigated circumstances, one of the questions I have is, I think, this has been covered multiple times, but I'm still having some issues with it. And that is, what's the point of the encouraging courts to use the different reasons that are stated there for mitigated or aggravated circumstances?
Yeah, well, I think the key reason is when we're going through processes like this of assigning offense gravity scores, what we find is, there are oftentimes, the majority of sentences are in the mitigated range or below the guidelines, but there's no reasons provided. Or it's because it's a negotiated plea. So if the commission was thinking about, well, should we change the assignment? It would be helpful to know, well, why are we changing it? Why is the sentence like too high? And sometimes it's just because, that's what's been negotiated. But sometimes it's because there's a certain factor that is a common factor that we just don't have built into the guidelines. So over the years, one of the ways that we have addressed those issues is when there's a common factor raised, we then subcategorize the offense. So you can think about like corruption of minors. For the longest time, it was a single offense in the crimes code. But when we looked at the data, we saw a lot of cases where there were aggravated sentences. And there wasn't any explanation for it until we really tried to focus on it. And we found that it was a difference between the nature of the corruption. Like sometimes it was alcohol versus not, and sometimes it was sexual issues, sexual whatever behaviors. And so the commission then used that to subcategorize and increase recommendations linked to that. So the idea of getting better feedback, first, it's required for departures from the guidelines, and we don't get very good reasons there. And then even for mitigated and aggravated, it helps the commission to consider changes to the guidelines so that there's greater uniformity in sentencing, which is what the commission is supposed to be doing for providing more targeted recommendations.
Well, I appreciate that, Mark. Is it still the commission's intent to include recommended sort of those specific examples of potential factors for mitigation or for mitigation or aggravation?
Yeah, I think where this all started was we were going to have adjustments for those more subjective reasons built into the guideline, like pre-sentencing. And I think the pushback both in public hearings and as we discussed as a commission was that's just not practical. So one of the resolutions was we should try to capture what those common reasons are and put them before the court at sentencing so that we can get a better articulation of why judges are doing what they are doing, but also sort of identifying these more subjective reasons at sentencing or these factors that are in place. I think what we're trying to do with the listing is not focus so much on aggravated versus mitigated, because some of these factors fall into both categories. They're used one way or the other. But more in terms of what are the factors that adjust maybe the offense issues, offense-related factors versus maybe offender-related factors, individual characteristics, character, stuff like that. So what we tried to do was come up with a little bit different formulation that it's not necessarily, that we point to it as an aggravating factor. We just say, here's a factor related to the offense. And did that influence the sentence?
Well, I appreciate that explanation. I mean, I can tell you that just by nature of being a DA, I mean, I just have a problem with seeing victim-induced or facilitated an incident. I mean, it just bothers me. I mean, I hate to be sort of, vague on why, but I mean, the reality is that, I see people grabbing onto that, and I see that turning into its own fight and litigation and argument when it comes down to sentencing hearings. And I would defer to the judges on the commission. I'm curious what their thoughts are on the impact of having specific I don't even know what you want to call it, examples of factors that can be taken into consideration on whether or not you aggravate or mitigate a sentence. I would be curious to know what our commission colleagues that are judges think about that.
I would say that the cheat sheet I use is just factors that have been developed through case law.
Mhm.
Whether it be mitigating or aggravating. And I cite to that when I work.
If
This is
there
just,
are-
look, I would agree, in essence, I mean, you have to give a reason for the sentencing. You have to. I mean, that's case law, so it's relatively easy to look down a list of things as opposed to scratching your head and grapple with what you're trying to do when it's already there. It's really not a suggestion, it's just a fact that you're just revealing.
Yeah, and we're just finding a way to try to get that into our data because it often is missing. So look, we're happy to remove things from the list. We're happy to add things from the list to the list. And so I appreciate you raising this specific one, and we can remove that. And I just encourage everyone to sort of look at that so that during the December meeting, we can, if we're going to keep a list, we have one that you're comfortable with taking to public hearings. And if we don't want to have a list at all, we should talk about whether we incorporate some of these things into SGS Web so that at least for purposes of reporting sentences, we have some better information or categories. Because sometimes we know judges at times will, photocopy our reasons reported for aggravated and mitigated and have them on the bench. And, they'll report 3A. And it's like, well, what's 3A? Well, it's, look at your list,
So I completely understand and I appreciate it. And it makes perfect sense to me. I know there's, I guess maybe I'm just stuck on, a victim facilitates an incident by just being there.
Yeah.
You
No,
facilitate an incident
we don't,
down the street
Yeah,
or,
yeah, and we don't want to be in the business of victim blaming, and I appreciate that. That was one of the reasons that was recommended during public hearings, and that's why we included it. But that's why you guys are commissioners in terms of helping us to sort of vet through a list and either add or subtract those that are listed. So I appreciate that.
Well, I appreciate the explanation. I appreciate the input from the judges that chimed in as well. So thank you.
Great.
And in addition, there's always room for the DA and defense to present argument or comment. So it's there. It's not like you're being blocked from saying or doing anything. It's there. But I can tell you, I mean, it really is helpful to have that. And it has been for me anyway. And I am one of those judges who, when I was sitting in criminal, who had that on the bench. As a matter of fact, I have a sentencing sheet with all the charges and everything. And on the back of it, I do have a section of mitigating and aggravating. And I look at it and that's part of the record. I just reveal why I'm doing what I'm doing. It just makes it so much easier. And at the same time, it gives the litigants counsel to state a reason why they agree or they disagree.
And in light of, Judge, and in light of what the 8th edition sentencing guidelines will look like, it seems clear that some of the ranges will be tightened significantly from where they were before. That I think will result in prosecutors and defense attorneys putting a lot more emphasis into their arguments on whether or not something should be aggravated or mitigated. And that's that was my thought pattern as I was thinking through this. That's all.
And I agree, and that just makes it more relevant in terms of what the judge will have to really do in terms of thinking it out. Because again, it is of record. It will be part of the appeal, should it be appealed, and it would have to be justified on the record.
Great. Thank you. Judge Downey?
I just had a question, and I may have been out of the room, but has the commission ever weighed in on consecutive concurrence?
It is not. We've discussed it a long time, and there has always been a concern that we're so focused on the individual offense and coming up with a recommendation for that offense, and then we're silent on what happens if there's more than one offense. So there's always been, I think, the discussion about doing it. The difficulty has been coming up with a definition that works. And so we want it to be fairly broad, and we want it to be a general recommendation, not particularly specific, but to provide some guidance. And the model penal code, the new one on sentencing, really does promote having a policy about concurrent consecutive. And so this is our first attempt.
And my other question, I guess, or observation, by way of a visual, have you considered like taking charges under the current guidelines and sentencing into current charges under the proposed guidelines, the sentencing, so you can actually see what the difference is?
One of the things that, and I think we should be doing that for the public hearings.
Yeah.
But one of the things is it's been sort of a moving target. So we need to sort of know what the guidelines are. And believe me, Christie has been after me to like have us know what the guidelines are, because when they're trying to do programming for a new application, they need to know what they are. So, but I think that's a great idea. And I think once we know what the final decision is, then we can map these things out. And in fact, that was one of the things I think that Brett talked about yesterday in terms of doing like a mapping of the current and proposed guidelines. So, great point. So I know we have to come to a close. Let me just mention one other issue regarding guidelines, and not sentencing guidelines, but parole guidelines. Back during the June meeting, the commission adopted the parole guidelines. And as I mentioned yesterday, we've been working with the parole board sort of on two tracks. One is to review those guidelines that were adopted to make sure that they're aware of how they would operate. And we were sort of vetting what was adopted by the commission. And then secondly, working with them to automate this so that we had a data collection system. And the board has been great in working with the DOC as well, in really developing a mechanism where they can incorporate the parole guidelines into their data system, and then also have a reporting of decisions to us. So we're really happy with the progress we're making with the board. One of the things we found, though, where there was a couple of areas where there were just questions. I don't think there was anything wrong or incorrect in what we did, but there was an interest in maybe having a bit of clarification about what was adopted. And so I've held off on submitting anything to the General Assembly and to the General Assembly for review, because we thought we would include a couple of definitions that would help clarify things and make a modest change to the document, the guideline form that we had as an example. And I just wanted to review this with the commission to make sure there weren't any questions before it was submitted to the General Assembly. So here are a handful of things. We use misconducts as one of the factors in the parole guidelines, and we actually use it in two different ways. We have general misconduct, and then we have when misconduct is assaultive behavior. And we use those in the guidelines, but we don't have them in our definition section. So, it's all explained there, but we define a lot of other terms in the guidelines, but we don't define misconduct being, how the DOC captures it, what data we're using. So we thought we'd add a definition of misconduct to the definition section. So it doesn't change the guidelines, it just explains misconduct. The second thing is there is a violence indicator on the guideline form, and we talk about violent offender. And in talking to the parole board, they use an instrument called the Offender Violence Risk Typology, or OVERT, OVRT, to determine if someone's violent or not. And we use that to develop the guidelines. It's in the guideline form, but we don't mention the OVERT. So we thought it would be helpful, again, in the definition section to just be clear about where the source is, because then if someone's just looking at the guidelines, they can figure out what we're relying on instead of just that it's a violent case. And related to that, the OVERT, one of the factors the OVERT takes into account is a 10-year look back period. And although that's built into the whole thing, we don't have that in the definition of violent offender, that a prior violent offense is 10 years back. So that's been part of all the analysis, but it's not in the definition. So again, in talking to Professor Mystic, these are very technical changes, but I thought I'd review them with you before we made those changes and submitted to the General Assembly. And then the final thing is on the guideline form itself. One of the things that we had was the type of case. And we had listed as the type of case, V for violent, NV for not violent, and RRI for recidivism risk reduction incentive. But when we talk to the parole board and we're trying to align what we're doing with what they're doing, their type of case is instead majority case, where a majority of the parole board members have to vote on the case, panel case, where it's like 2 members of the board have to vote on the case, or RRI. So we just want to align the categories we're using with theirs so that we're just on the same page. So these are minor changes, but again, they're different than what we published in, for the public hearings and what the commission adopted. So I wanted to just make sure there weren't any concerns or questions about that. As I said, I've reviewed it with Professor Mystic. These are technical changes, but I wanted to at least bring it to your attention. So unless you have any concerns, I will be, submitting this in the next week or two to the General Assembly through the bulletin. They'll have a 90-day review period, and we anticipate that everything will go into effect January 1st of next year for the parole guidelines. I am also meeting with the parole board next month during their retreat, and we're spending a whole morning reviewing the parole guidelines and then working on the recommitment ranges, because at the last meeting, the commission tabled the recommitment ranges. And part of that was trying to figure out, what do you do with new conviction offenses? What do you do with some of the technical stuff? And there were some concerns raised by the commission, and I think that we can just do better than what we have right now. So I'm going to be meeting with the parole board. So I'm hoping that for the December meeting, in addition to having the draft sentencing guidelines, you'll also have draft parole recommitment ranges. And then the final thing, and the chair and I talked about this, one of the other things that we want to consider along with our sentencing guidelines are our resentencing guidelines for probation violations. And we heard a lot of public comment about some of the work we did on looking at technical violations of probation linked to drug dependency. And so I know the chair has had meetings and discussions with others. We've talked about it as part of the Vital Strategies project we did. And we heard some of that during public testimony about thinking in terms of recommendations for drug dependent offenders. And so one of the things we'll look at for coming up with the draft resentencing guidelines to be consistent with the sentencing guidelines is trying to incorporate some of that and giving you that draft during the December meeting as well. So mark your calendar, December meeting, that Wednesday, sentencing guidelines 8th edition, resentencing guidelines to go with the 8th edition, and parole recommitment ranges. 3 drafts that we'll be reviewing, anticipating that on that Thursday, December meeting, we will ask you to approve those public hearings early next year. And with that, I think we are done with the policy meeting.